দেখো মেনশন আছে
Please, Your Lordship. Lordship, this application is for recall of an order appointing the arbitrator. Your Lordship may remember Mr. Thakkar was making submission. There were twofold arguments which he was seeking to make.
Twofold. Please be a bit louder. Yes.
My apologies, Lordship. Your Lordship, the twofold arguments were, one was that the application for Section 11 was filed before expiry of 30 days from the issuance of notice under Section 21. The second one was that there is no arbitration agreement and they have forged a document and the order was passed ex parte for appointment of an arbitrator. Lordship, on the first point, Your Lordship may kindly see the Section 21 notice which they had sent. It is at page 51 of the application. Though, Your Lordship, in the affidavit we have stated that we never received it, but nonetheless, because it is page 51.
Yes.
Lordship may see it has been addressed by some Vidyashri Majumdar.
Yes.
And written, though the ID looks correct, the Navkar Builders, but we never received it. We have stated it on oath. And Your Lordship may kindly see the letter.
This is an email.
It's an email.
It's a valid email. You don't say that it was not your email on that date.
No, because as per the MCA it is there, but it was never received by us.
All right.
But nonetheless, Your Lordship may see the date of the email is 26/6/2024.
Right.
And it states that we are writing as a reminder in furtherance of our earlier notice issued on 21/5. That notice, Your Lordship, it has been annexed, but Your Lordship, it was admittedly never served. Because
admittedly never served.
Never served. It writes, the email itself writes it. Your Lordship may see the third para of the email. It only writes that, however, to our, Your Lordship may see, however, to our
shifted from the given address.
So they have admitted it, but Your Lordship may, I'll show the letter that was never sent by post. It was supposedly sent by Blue Dart, but there is no consignee slip. They have just attached the letter and some kind of a tracking where it says that something is moving from Kolkata to Ahmedabad and Ahmedabad to Kolkata. Nothing from whom to where. So they have not gone for it. They have simply wrote an email that we had sent and it was never delivered. So, Your Lordship, now they have sought to invoke. The letter date is 26/6/2024. The filing date of this Section 11 application was 23/7/2025.
25.
24. My apologies, Lordship.
Otherwise, it would be much beyond.
No, Your Lordship, then I would not be here only.
You would not be here. Yes. Or you would be here with a different matter.
Then without Section 5.
Yes. So, very well. So, this is the first point that, and you took a point of forgery of that agreement.
Yes, Your Lordship.
They probably have a worst case because that may be decided by the arbitrator.
No, Your Lordship may kindly consider that the forgery of the agreement itself, it's a criminal act. It has come before Your Lordship. The arbitrator cannot adjudicate. Your Lordship, Mr. Thakkar will cite several judgments. There are two, in Rashid Raza and in Avitel also, the Honorable Supreme Court.
In effect, this is a review application. Recall, there is no problem.
No, Your Lordship, because it was passed ex parte.
Ex parte, but you were served with notice of the Section 11. You were served.
Your Lordship, it was served by email. Again, we have admitted yes that we had received. It was again by email.
Email, maybe email is a good service nowadays.
Yes, so we are not dismissing it. Like the Section 21 application, we are saying we never received this letter, but the Section 11, yes, we were served. Now, Your Lordship may see that the matter goes into the root of it. There is no arbitration agreement. The time period for Section 21.
Have you ever taken before any?
Yes, Your Lordship, I'll tell the background of this matter.
Did you lodge a police complaint or something?
No, Your Lordship, because there are several, it has happened one by one. Because, Your Lordship, this is a matter which has come as a counterblast to a NCLT application which is pending before the NCLT Delhi. Your Lordship, the relation between the applicant in Section 11 and us is that we had issued a work order on them. and we had paid them some money on that behalf. They never executed the work. It was a work order was around 10 crore rupees. They refunded something around 7 crores or 8 crores. The remaining balance they were not refunding. So we filed an
They
application.
had not delivered the goods.
No. It was a work order, though they never did
They
anything.
did not do the work.
They did not do the work. So the application was pending before NCLT Delhi. In the meantime, what they did
NCLT application was regarding what?
regarding recovery of money which they owed to me.
All right.
Now, what they do is that
NCLT?
because, Your Lordship, it was an admitted due which we had given, and that is pending. That is still pending.
Very good.
This matter was filed to create a dispute.
There you took a point of forgery.
Yes, Your Lordship, but there this document never figured out.
Surfaced, right.
There they surfaced a similar kind of a document. The money which I had given to them, they said that no, you have given it on account of some third party. So on that also, that was a forged document. We had taken the point. We had filed forensic reports. The forensic report is here also. So in the meantime, they devised this argument that yes, no, you have not given us a work order. I have given you a work order, and I have given you the money. The 10 crore rupees which I gave to them, that they are simply omitting in the section 11. The money which they have refunded subsequently, they said that no, this money which
that
is
would be somewhat
yes,
going into the merits.
That is in the merits. I'm not
primarily 2 points. One is 30 days. Second is that it's a forged document.
Yes, there is no.
And you had no opportunity to take this point before. But your ground is that NCLT, before NCLT, a different document was relied on by them.
Yes.
But this forgery allegation you never took because you did not have any opportunity.
No, this was the first document, like
Very
the
good.
section 11 itself.
Very. Let us hear them.
Your Lordship, may just hear Mr. Thakkar. I apologize.
We heard Mr. Thakkar on the earlier occasion.
Yes, Your Lordship, he had just not cited the judgment. If Your Lordship,
the judgments, you know the judgments.
Your Lordship, my apologies, Your Lordship, he had brought.
Don't have copies.
I have the copies.
That brief is not with you, which has the copies.
No, Your Lordship, I just have some difficulty in those parts. Because Your Lordship, he had only asked me to start with the merits and he'll read.
You have started.
I apologize, Your Lordship.
Mr. Thakkar has very bad apprehensions about the code.
No,
Take more
Your
time.
Lordship, no, Your Lordship, he has come very prepared for this matter. But
Yes.
if
Where is his checkup? He's in court, no?
He's in court. He's on legs, I was told. Your Lordship, Your Lordship may only consider 2 judgments which I'll cite as regards the.
Give me half a minute. I'll take the notes of what you argued so that
yes, Your Lordship. I'll just
you get some
the
time
judgments.
for Mr. Thakkar. You can take your seat. You can take your seat. Yes, what are the judgments?
Your Lordship may kindly have a look at the judgment in Vidya Trolia. It talks about
yes.
Your Lordship,
on what?
Your Lordship, it's on the issue of 2 kinds of fraud. One which goes into the root of the matter. Your Lordship, my apologies. It starts from page 1.
I would take the point of maintainability, Manoj.
You're also there. Yes.
I am for the respondent.
Obviously, yes. Which paragraph?
Your Lordship may see paragraph 73 at page 71. It cites the judgment in Avitel as well as Rashid Raza with authority.
The serious allegation of forgery. So
Yes, Your Lordship.
yes. What else?
Rashid Raza देता है? Your Lordship may permit me to cite one more judgment. It is the judgment in Rashid Raza, 2019 8 SCC 710.
Yes.
Yes.
Your Lordship, I'll just give this para 4, Your Lordship. May I place it?
Same tests.
See, Your Lordship, Vidyatrulia refers to both of them.
Yes.
Your Lordship, I'm just
This was referred to in Vidya.
And Avitel, Your Lordship. Your Lordship may kindly permit Mr. Thakkar to make submissions.
There are judgments to the effect that arbitration clause can be segregated, but here you say that it permits the entire contract.
Your Lordship may kindly hear Mr. Thakkar.
Yes.
Your Lordship is absolutely right. The arbitration stands on a separate footing.
Yes.
Here, if the arbitration agreement is contained in a document which is execution or which is disputed,
But it permits the entire.
Permits Your Lordship to enter because 11.6a test also says existence.
Yes.
And existence has been held to be valid existence in Cox and Kings. So the validity of the existence of the arbitration agreement can only be determined by the referral court because it goes to the root of the arbitrator's jurisdiction. It does not fall foul of 16. Because it's, so that is why, my lord, if your lordship now also sees Avitel once, Avitel, right? Yeah. Kindly have Avitel. This considers Rashid Raza, kindly come to paragraph 35 of Avitel, please, my lord.
Yes.
Fraud per se is arbitrable. Kindly give me paragraph 35. Avitel.
Paragraph
35, please, my lord. After discussing Swiss time, Maestro, and everything, kindly come to 36 on. 35. 34, Rashid Raza, my lord, it is page 753 of the report.
Yes, thank you. Got it.
In a recent judgment reported as Rashid Raza, this court referred to Justice Sikri's judgment in Ayaswamy. Then Rashid Raza is cited with notice with approval. Then kindly see 35. After these judgments, it is clear that serious allegations of fraud arise only if either of the two tests laid down are satisfied, record copy, and not otherwise. The first test is satisfied only when it can be said that the arbitration clause or agreement itself cannot be said to exist in a clear case in which the court finds that the party against whom breach is alleged cannot be said to have entered into the agreement relating to arbitration at all. So if I'm not, in my case is that I've not entered into any arbitration agreement, this is the exception carved out. I don't say that there's breach on my part or the contract was procured by fraud from me. I say that the contract is non-existent. That is the distinction, my lord. It's not procured by fraud, but it is non-existent. Now, my lord, I will be failing if I don't show your lordship, my lord, what I think is the latest on this. This is in August this year. The facts are exhaustive. Kindly come to, my lord, where the law is now summed up. In this case also, my lord, the existence of the arbitration agreement was not in dispute. Can you see paragraph 17? Allegations were of fraud and criminality once the agreement had been entered into in the manner of working out of the contract. And this was relating to the public distribution system of the state of Bihar, and it was contended that the whole contract was worked out in fraud. That there was monies were taken from the distribution system without the distribution actually taking place. Yes. So this is 17. Now, kindly come to the issues, which is at page 18 of the report. Issue. Whether the dispute between the respondents and the appellant arising out of the agreement incorporating the arbitration clause has become non-arbitrable in view of the initiation and pendency of the criminal case. Then, my lord, kindly see 4. And that is on the issue of this. So this is, my lord, and kindly see issue 6, where the issue numbers 1 to 5 should be left to the arbitral tribunal to decide in view of subsection 6A of section 11. This facts of this case not strictly attracted to our case, but because this is the latest judgment which considers the entire law on the subject, I'm troubling you with this, my lord. Kindly see, my lord, paragraph 5, principles governing arbitrability in cases involving allegations of serious fraud, at page 19 of the report.
Yes.
So under this heading, my lord, the Supreme Court considers all the judgments starting right from, my lord, Rashid Raza, everything, Amit Lalchand. Kindly see serial 6 at page 20. Yes. Serious allegations of fraud. Now kindly see issue 6.
Yes.
At page 21, scope of inquiry by the referral court when an application under section 11(6) of the Act is opposed on the ground of serious fraud. Now, I'm not troubling your lordship with all this thing. Now, kindly come to where this law is now summed up. Paragraph 28. We have examined the matter in detail. There is an arbitration agreement. So, once the agreement is not disputed, the matter is to be referred to arbitration. But when the agreement is disputed, kindly see now under paragraph 21, where the principles are laid down by the Supreme Court in this decision at page 19. Working out of the agreement or the parent contract is vitiated by fraud, there are criminal cases, all that is arbitrable. But where the existence of the agreement...
This is which paragraph?
Paragraph 21, my lord,
yes.
Page 19.
Yes.
Now, my lord, after considering Ayaswamy, Rashid Raza, Avitil, we are of the opinion that a judgment need not be burdened by extracting excerpts from the judgments all over again. Instead, we seek to restate the principles as follows. This is the, my lord, access to justice. I'm not troubling your lordship with, my lord. Kindly come to serial 5. Roman 5, my lord, at page 20.
3 may be also relevant.
3 may also be relevant, my lord. Same sets of fact may lead to civil and criminal. A civil dispute could involve questions of coercion, undue influence, fraud, misrepresentation, For example, and such disputes can be adjudicated in civil proceedings for determination of civil or contractual liabilities. The same set of facts could have their correlatives in criminal law. The mere fact that criminal proceedings can or have been instituted in this would not per se lead to the conclusion that this is an arbitrability, my lord. Because the criminal proceedings, your lordships have seen the catena of judgments, findings in criminal proceedings are not binding in civil courts. Both can continue because the consequences are different. One is imposition of penal punishment under the criminal jurisprudence. In civil,
Here you are on a higher footing. The agreement itself.
yes, my lord, that is recapitulated here in serial 5, please, my lord.
Yes.
For an important policy consideration at page 20. For an important policy consideration, our court has drawn a distinction between serious fraud and fraud simpliciter to segregate and exclude disputes involving serious fraud from arbitrability. Disputes involving serious fraud may not be submitted to arbitration as explained to some extent in Ayaswamy, as they are very serious allegations of fraud which make a virtual case of criminal offense, or where allegations of fraud are so complicated that it becomes absolutely essential that such complex issues can be decided only by the civil court. So this is limited, my lord. That is why the Supreme Court says in this decision, to some extent. Then kindly see 6. Serious allegation of fraud is to be understood in the context of facts. In Rashid Raza, this court laid down 2 tests. The first test is satisfied only when it can be said that the arbitration, kindly see, arbitration clause or agreement itself cannot be said to exist in a clear case in which the court finds that the party against whom breach is alleged cannot be said to have entered into the agreement relating to arbitration at all. This is my case, my lord. It is to be decided by your lordship. The second test can be when the state, my lord, I'm not troubling your lordship with this because these are not the state. Kindly come to 7. Disputes involving allegations of serious fraud need more clarity so that there is certainty about the availability of the remedy. At least one instance of serious fraud will be where disputes involving allegations of criminal law implications transcend interstate disputes between the contracting parties, public law implications. Because here, my lord, this was concerning this public distribution system. Then kindly say 8, I'm sorry. Arbitral tribunal will be within its jurisdiction to consider allegations of fraud even with respect to the specific terms or clauses in the contract, as an arbitration agreement stands independent of the contract and continue to bind and govern the parties, even if the contract is terminated or challenged. And this question is no more res integra. There is, however, an exception that follows in its articulation. So this is, my lord, the competence principle. You can decide on fraud and as well as your own jurisdiction. 9. However, the allegations of fraud with respect to the arbitration agreement itself stand on a different footing. This position is generally recognized as a dispute which is in the realm of non-arbitrability. This is something, my lord, which the tribunal is not competent to decide. The very existence of, my lord, if I may say, my lord, the foundation of its existence, the tribunal's existence itself in a question mark, that, my lord, the tribunal cannot be the judge of, perhaps the judge of its own cause. Whether there is an arbitration agreement itself. In such cases, the tribunal will not examine the allegation of fraud, but will consider the submission only for the purpose of examining exclusion of jurisdiction. This principle in its application can be seen in the judgment of this court in Avitel. And of course, the burden of proof is on the party who raises this plea, that is in this case me.
Mr. Thakkar, let us take a hypothetical situation. A suit for specific performance is filed on an agreement.
Yes.
I file the suit against you.
Yes.
So you take a point that no, it's tainted by fraud. Challenging the execution of the agreement itself is in doubt because it's tainted by fraud, as in 9. So in that case, if it's filed in a civil court, there is no arbitration clause. So what would be the situation? Then the civil court should wait for a criminal adjudication because to parallelly proceed. No. What the civil court can do, why can't the arbitrator do?
My lord, when your lordship says, I follow, my lord.
I understand that this speaks. I am in the teeth of this. I'm saying this.
But what will happen? Fundamental differences here.
Yes.
My lord, the civil court gets its jurisdiction. From the constitution. There's no question of conferring jurisdiction on a civil court. It's not consensual. It's not contractual.
If there was no section 9 of the Code of Civil Procedure, would there be any jurisdiction vested in the civil court?
So, my lord,
we don't think that.
No, my lord, section 9 of the civil
hierarchy comes from Bengal Agra Assam and civil court powers come on from
civil court under section 9. If your lordship kindly see the CPC, this jurisdiction of civil courts unless expressly barred. It says
So section 9 is the section which confers jurisdiction on the civil code. Otherwise,
my lord,
there might be some other code.
so I follow.
Might be the panchayat. Tomorrow it may become the panchayat.
Yes, my lord, and the way things are going. But I follow that, my lord. But then it does not require contract between the parties. Arbitration, the genesis of arbitration is a contract between the parties.
Yes, but merely because section 11 court also cannot decide whether it's a fraudulent document or not. Obviously, it cannot decide.
No, my
Cannot-
lord, my lord, the difference.
No, no. Just let me complete
Fraud
this
in-
sentence.
I'm sorry.
Just one sentence. Section 11 court
Upper
cannot
limit
decide,
रहेगा.
but section 11 can take note of a fact that you have raised that question.
Yes,
So that question is involved. Section 11 court can only take that into consideration.
my lord. What I understand what the Supreme Court means to say here and in Avitel is there can be frauds of two kinds, and here we are considering the fraud which your lordship is perhaps contemplating is that the agreement has been procured by fraud. The existence of the agreement is not disputed by either of the parties, but the contention is that the agreement, for example, in a suit for specific performance.
We understand. I understand. One is that but that is more rather than
It's
fraud.
forgery.
Not only forgery, then it will be either misrepresentation or coercion or something like that.
This can be decided by the tribunal.
No, we are trying to distinguish here fraud from coercion and misrepresentation, because if by virtue of some you are duped into entering into some agreement by coercion, that can only be by coercion or misrepresentation or some other thing, not
Arbitral.
fraud.
Arbitral.
If it's fraud, it has to be the agreement is manufactured by fraud
Correct.
or forgery.
So it is
So if the
fabrication.
fabrication, forgery,
Yes.
manufacturing the agreement, whatever term,
Yes.
so procured in that sense, in the bad sense.
Yes.
So it's a bad touch procurement.
My lord.
So now then it's a very act of manufacturing of that document which is tainted by fraud. So if I file a civil suit, we are going back to the same analogy. What does the civil court do? Wait for the criminal court to adjudicate or
The civil
decide
court
that
adjudicate.
question on preponderance of probability
That the civil-
independently of the criminal action?
Exactly what has fallen from your
If
lordship, the latter.
that be so, why whatever the civil court can do, the arbitrator can now do. Previously, there was some doubt. You know better than
Yes,
me,
yes.
in fact.
No, no, my lord.
that civil courts, yes, the detailed questions of facts and evidence and all,
No, no,
civil courts
that
should
is
go to the
gone.
civil court. Those are gone. Those days are gone. No, now the arbitrator, whatever the civil court can do, the arbitrator can do.
Yes,
Appointing experts
act
and
has been act has been amended.
so
The-
then, if similar circumstances, civil court could take it up. Why can't the arbitrator?
Because for the simple reason that then because there is no contract to arbitrate.
So what happens? The Section 11 court says a question of forgery has been raised. So there will be no arbitration.
No,
Then
your
what
lordship
happens?
then your lordship will go into whether there is the forgery is there or not there. Your
So
lordships will decide.
that going into has to be done by the Section 11 court, but cannot be done by the arbitrator, you were saying.
Because
Wouldn't it be putting Section 11 on a higher pedestal than Section 16?
yes, because they operate in two different, with the greatest of respect, operate in two different circumstances.
Yes.
Why? Because
Then Section 11 court will take prima facie evidence and decide.
my lord, there's one more two-bench judgment which says exactly this of Justice Shah in the Supreme Court. The existence, even after 11(6)(a),
Yes.
has been held to be the finding of the Section 11 court. Section 11 court has to be satisfied that there is an existence.
Hmm.
Now, if that existence has been held to be a valid existence, my power of attorney, supposing I put it in a specific performance arbitration, my power of attorney goes and signs a document selling my land.
Whatever you say, that is decided by the civil court.
Because that civil court
But the arbitrator is a substitute of the civil court, not the Section 11 court.
that slight difference there. An arbitrator can exercise the same powers as the civil court. There's no dispute about that. But the arbitrator cannot be equated with the civil court because it has no existence of its own without a contract between
It is
the
not clothed with power if there is no
contract.
No
If-
contract.
If there is no contract,
Arbitration clause, basically.
yes, if there is an arbitration clause or an arbitration, that is with the greatest, the fundamental difference between a civil court which does not require jurisdiction to be conferred upon it. It has
Party autonomy element is not there.
You have to come and defend a
The law,
civil
you
suit.
have to come there.
You have to come here, but I cannot be compelled to go to arbitration if I have not entered into an agreement to arbitrate. The civil, if your
I
lordship,
cannot even imagine a Section 11 court putting witnesses on dock and cross-examining.
my lord,
That's my mindset.
yes, but then now, my lord, the law seems to have been Rashid Raza. My lord, first they said that allegations of fraud cannot be decided by the arbitrator. That is what the Supreme Court said in Maestro. Then came Ayya Swami saying exactly what your lordship said. Allegations of fraud can be decided by the arbitrator, but then drawing the distinction between fraud simpliciter and serious fraud. That became further refined with Rashid Raza. And Rashid Raza categorically says that if the question is leading to the existence of the agreement, then my lord, it's a bedrock of arbitration, whether there's a
Yes.
So if the bedrock is shaken, then I cannot be compelled to arbitrate. That is the fundamental, my lord, logic, it seems to me. Nobody can be compelled to arbitrate unless he has agreed to arbitrate. And that is what your lordship decides. Can I be, my lord, sent to a domestic forum if I have not chosen to go to a domestic forum? It's not that the litigant is remediless.
Somewhat shake the concept behind Section 8 also, in a sense. Why
Yes.
I'm trying to explain, Mr. Thakkar, maybe I am not so articulate as you. I mean,
No, my lord, kindly.
no, I'm not. I'm just trying to express myself. So Section 8 court, a suit is filed before a civil court.
Yes.
Parties have a choice. If they don't file Section 8, civil court continues. So it's not inherent lack of jurisdiction before Section 8 is filed. Once Section 8 is filed,
I'm great.
civil court shall.
Shall.
So once Section 8 is filed, is the civil court which does not have jurisdiction, which is deciding that it should go to the arbitrator. So a forum which does not have jurisdiction
Send
is
it to
deciding.
forum.
Even before a civil court. I mean, if yes, you are right that the jurisdiction of the civil court is not in question if the clause
Agreement
is
is-
tainted.
Now, Malad, there is,
Very well.
I will cite today, Malad, I'm sorry, Malad, this analogy between 8 and 11. Now there is authority that if the 8 is dismissed, the 11 is automatically dismissed. The decision in 8,
No, it was on a different context.
no, I follow what, but
8,
Malad,
11, that interplay is there.
yes. So if 8 is dismissed, 11 is not even entertained because it operates as res judicata.
8, I have my notions on that also, because 8, first of all, you were a civil court which is doing it.
Yes.
Civil court has certain powers. When I take up the matter, suppose there are some of the disputes are, say, some of the parties are extra, or some of the civil court has the power under Order 1, under Order 7, Order 6, to delete some of the parties or segregate the matter also as a civil court and then send it to arbitration. But that is not available before a Section 11 court. Section 11 scope is very limited.
Malad, in that limited scope, Malad, it's a 2-judge bench. I've shown
But
you,
please
Malad,
cite that
subsequent-
Justice Shah's judgment.
Yes, 2023-8 SCC 50. वो Cox and Kings बड़ा वाला निकालो। तू बुलाया मेरा Cox and Kings देखो। Kindly see, my lord,
Yes.
paragraph 8 onwards. Kindly see 7 onwards. I'm so sorry.
Right.
Heard, the short question which is posed for the consideration of this court is the jurisdiction of the referral court
Yes.
at a pre-referral stage when the issue with respect to the existence and validity of an arbitration agreement is raised. While considering the aforesaid issue, 11(6)(a) has to be considered. Thus, post the Arbitration and Conciliation Amendment Act 2015, the jurisdiction of the court under 11(6) of the Act is limited to examining whether an arbitration agreement exists between the parties, nothing more, nothing less. Thus, as per 11(6)(a) of the Act, it is the duty cast upon the referral court to consider the dispute or issue with respect to the existence of an arbitration agreement. At this stage, it is required to be noted that as per the settled proposition of law, pre-referential jurisdiction of the court under 11(6) is very narrow and inheres 2 inquiries. The preliminary inquiry is about the existence and validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and the applicant's privity to the said agreement. The said matter requires a thorough examination by the referral court para so and so. The second inquiry that may arise at the reference stage itself is respect to the non-arbitrability. Both are different and distinct. My lord, kindly make a note, my lord. This decision, well, I must tell you, lordship, my lord, the said matter requires a thorough examination. This is no longer good law because NTPC has been overruled in a subsequent decision. But kindly read further, 11. So far as the first issue with respect to the existence and the validity of an arbitration agreement is concerned, as the same goes to the root of the matter, the same has to be conclusively decided by the referral court at the referral stage itself. Now, so far as the non-arbitrability of the dispute is concerned, even as per the law laid down by this court in Vidya Dolia, the court at pre-referral stage and while examining the jurisdiction under 11(6) may even consider prima facie examining the arbitrability of claim as observed to cut the dead wood, etc. However, so far as the dispute with respect to the existence and validity of an arbitration agreement is concerned, and the same is raised at the pre-referral stage, the referral court has to decide the said issue conclusively and finally, and should not leave the said issue to be determined by the arbitral tribunal. The reason is that the issue with respect to the existence and validity of an arbitration agreement goes to the root of the matter.
Do you have any case, Mr. Thakur, where fraud was decided by the Section 11 court? I accept that this is.
No, my lord.
Have you? I've never seen. I've never come across any case.
My lord, I only did a search on the Supreme Court. I'll search for the other high courts. Of course, they are not binding on your lordship,
No,
but
no,
they might have some.
Interesting reading at least.
My lord, 12, my lord, perhaps, my lord, nails the issue. So does, my lord, the last judgment which I showed your lordship, my lord, the
Broadly, yes. On the principle, you're
of
right.
existence.
It has to conclusively determine
Conclusively.
wherever it touches the
Yes,
validity.
becomes an issue of non-arbitrability only because, my lord, the little that I could understand is because the tribunal does not have jurisdiction by itself.
It is not clothed with
It's
jurisdiction.
not sui generis.
Because there is no party agreement then.
Yes. So whether the agreement is there or not, if the agreement is vitiated by, my lord, the difference between, I am not on, my lord, fraud, I am on forgery. I have not signed this agreement. That is an issue which can easily be determined by the referral court. If I may give an example, if your lordship allows
If
this.
it was forgery, we could have easily just lodged a complaint and sent it.
No, in the facts of this case, I filed a proceeding before the NCLT to institute to start CIRP. This agreement surfaces after that.
In forgery,
because-
you have to form a prima facie opinion and just send it for
Yeah.
criminal trial. But here, yes, very well.
So, my lord, this agreement came about.
This is your second point, because first I have to
First
check,
is a clear
because
point.
you were given a notice and you did not appear on that date.
I
your client.
Yes.
So did not
Please
appear on that date. So this point was never taken as
This
such.
point could not be
But
decided.
30 days point still remains.
30 days, with the greatest of respect, it was for him to satisfy your lordship.
Yes.
That 30
No,
days has
30 days-
expired.
30 days can be.
Those facts were not brought to your lordship's notice. If your lordship sees
That email was produced before us, probably, because that email.
yes, your lordship will.
And that email also indicates, as was rightly pointed out by your quite able junior, that that agreement, that email itself says that previous notice came back with the endorsement left or something like that,
Left,
which is not good service.
Not good service.
If it's not good service, then this is the first email, and then the dates are
Dates are speaking for
date of the
themselves.
email and the section 11.
Yes.
So that remains.
So, my lord, the notices of 3rd March 25. Sorry.
The dates we have taken. 21st of May was the first notice allegedly.
Yes.
You say you did not receive, and the
23rd July.
2024 email is the second notice, where it is mentioned that the previous notice was not properly served
Not so.
because the endorsement. And then 23rd section 11 is filed. So it's within 30 days from 26th of June. Right.
Yes. Well, this is now fairly covered in the BSNL Cox and King. I'm sorry, BSNL Nautel.
What is covered?
That this 30-day, my lord, is bad.
No, 30 days.
Yes, the law statute itself says it, my lord.
Yes.
So, and then, my lord, there's of course the condonation of delay application is there. There, your lordships have.
In filing this.
Beg your pardon. Yes, yes. There is a.
What is the reason?
My lord,
Give us an easy way out not to go into this. What is
my
the
lord, your
delay?
lordships have held the delay, my lord. Your lordships have held the delay does not come in the way of.
We have held many things. What is the delay here?
My lord, kindly have my application.
Just give me the number of days.
A1. IAGA 1, 255 days delay.
Reason?
My lord, 255 days delay in filing the recalling application. The reason being, one, my lord, the second email was received. The section 11 application was not served by post. Again, not served by post.
No, the delay is after the passing of the order under section 11. So what was the reason for that?
The delay in passing after the order. Yes, we came to learn only after the tribunal. We received notice from the tribunal that it has been constituted. But my lord, since the section 11 was served upon me, I have computed delay from the date of the order. It's like the writ of summons analogy we draw, my lord. If the summons has been served upon you, then you cannot count delay from. So I have counted from the date of the order. If I count the date from the tribunal, then of course it's. But I have to count the date from the service of the section 11 application.
So
Again, not served by post. Not served by post. That is admitted. Sent by email. Email is good service. There's no difficulty. The email was omitted, my lord, because I've said.
If in modern days of arbitration,
Yes, of course, my lord. Email.
EDR, you rely on postal service, which is now even scrapped probably some of the services.
My lord, speed post is there.
Yes, the
There's
boxes,
general
the letter
clauses,
boxes are no longer there.
general clauses, that is hand. My lord,
When the WhatsApp is so many goodbye messages by the letter boxes.
my lord, the only explanation which has been given for the delay is the demise of the patriarch of the family. This is a closely held limited company. The family was in grief. The patriarch was ailing before that. He passed away. The email was missed. And after 5 months, my lord, of the passing of the arbitrator, the notice was served.
You came out of your grief after 5 months.
No. I came to know after 5 months. Well, the email
You have
comes.
been attending NCLT and other proceedings in the meantime.
No, my lord, the NCLT proceedings are happening in Ahmedabad. So that is a lawyer's appointed. This is a fresh proceeding. Kindly, my lord, do not draw an alliance. This is a fresh proceeding where a lawyer has to be engaged. The NCLT is an ongoing proceeding.
When did he die?
He died on, my lord, the date is given. 6 February 25 now, my lord. 6 February 25, I received the first notice from the arbitrator. Your lordship's order
Yes.
is of 18 September 2024. So, my lord, from September 24 to February 25 is 5 months, 150 days are gone there out of my 255 days. But I am hit because the section 11 was served on me.
So first notice for arbitration from arbitrator, and you filed this on?
I filed this, my lord. I received this notice on 6 February 2025, and I filed this, my lord, on 4th July 2025.
Why these 3 months?
No, my lord, because we needed to obtain
5 months.
Yes. No, my lord, the parties were in the company is in Ahmedabad. The applicant company is in Ahmedabad. They made mistakes in the notarization, printing.
No, when did the patriarch die?
Patriarch died, my lord. Kindly give me a minute. The date is mentioned in 28th August 2024. He was suffering for more than a month, then he passed away. And that is why, my lord, this email of communication of 31st July 2024, by which the section 11 was served.
So you had 20 days between the section 11 being served and the demise.
Yes, my lord, but he was
So
suffering.
you couldn't have been retrospectively.
No, he was
in
pleading is, my lord, he was suffering. Whatever is there now, the client has affirmed on oath. And, my lord, as far as filing this application, my lord, I had the applications were all wrongly notarized. They had to come, go back. Then he ultimately came to Calcutta because we found that he was not able to affirm properly. All the prior applications are here.
Yes.
My lord, in the Lipak Auda, Lipik Au. My lord, when, my lord, your lordships have held that when the limitation, of course, is a statute of repose, it has public
Quality of the explanation given.
quality of the
not
explanation, not the time, number one. And number two, my lord, when your lordship sees that on merits, something has to be said. And he has
That after two judgments, Justice Bela Trivedi and Justice Pardiola's bench, probably that cannot be taken into consideration merit. There are two judgments I don't recall, I don't remember the citations in.
my lord, but
Two recent judgments by two judge benches of the Supreme Court. Both those cases, one relies
I'm
on
sure
the other.
Mr. Banerjee will side them.
Must be must be having those, and we are in great difficulty nowadays. The mindset is not
my
yet
lord, I
changed,
will
but
look up
the law
those,
has
my lord.
changed.
I'll look up, but I,
My lord, to this extent, my lord, on a Friday morning.
my lord, decisions are there, my lord, but I don't know where the decision happened.
Yes.
I'll look up that. But, my lord, if
Certain
there,
decisions that merits cannot be looked into, even as a mitigating circumstance in Section 5. Anyway,
contrary to, my lord, previous decisions, I don't know how far, whether they've considered the previous or not,
all High Court, Supreme Court, all along
have said,
same view that merits can be one of the considerations.
yes, can be one of the
Not the
considerations.
main consideration,
Not
can
the
be
main,
one of them.
yes.
That has been changed now. So I'll carry those judgments for
For me.
people like you who trouble us with intricate questions.
But, my lord, whether they, my lord, consider the previous law, because then I will say, I can argue that if they have not considered the
Try
previous,
and argue that before the Supreme Court, please, Mr. Thakur. We are already in much trouble. High Courts.
I will rest. I will not say.
Yes, Mr. Banerjee, now you.
My lord, there are two issues to it. Is that, my lord, before, my lord, I show the judgment law, my lord. My lord, kindly sees the facts and the law as it is. This is an application, he says, my lord, where the section 11 was not filed. It's not correct. I can file an opposition also. That is why I said, my lord, that
Section 11 is not filed?
section 11 was not served on him.
Email service was made.
My lord, he was not aware of 30 days time was not over.
Email service I'll deem to be
Not
good
only
service.
that, he says 30 days time was not over. There was
30 days time
bereavement.
was not over there.
Malad, I can file an opposition. My opposition is ready with the documents that this was initially filed, Malad, under the commercial division. Correct?
Non-commercial.
Non-commercial.
Oh,
Withdrawn, file under commercial division. Before, when it was filed, my lord served on them several times. After it was withdrawn, served on them several times.
no, Mr. Banerjee, Mr. Thakkar argued that the first service was by email on 26th of June 2024. That email you had probably annexed to the section 11.
I
also.
have got all the emails annexed in my opposition. May I just place the facts?
There were previous services also.
There was service made to him previously. There was, my lord, 21 notice served on the same email ID. There was, my lord, withdrawal made upon service. There was, my lord, this fresh application filed under commercial division, my lord, served on him. There was, my lord, after the order passed, there was a mistake in the order with the name of the arbitrator mentioned upon, my lord, service. Then, my lord, he appeared before the arbitrator upon service. He has filed a statement of defense also, which he has suppressed. He is not saying before this court. He has filed a statement of defense. Now, my lord, there is a very interesting law which has changed now. Section 11 court cannot interfere. Kindly takes the section 16 first before looking into any law. And this law is also settled, my lord. Kindly takes the section 16 provision, my lord. He has filed a statement of defense, admittedly, before the arbitrator. Yesterday, on a lighter note, before I place section 16, yesterday night, my lord, I was looking into, my lord, before going off to sleep, my lord, a video of a very luminary in legal profession. Nowadays, my lord, lordships have this podcast and all.
Yes.
Now, my lord, he was being asked about the legal system in India. He said it's rotten, my lord. His language was rotten, not an unparliamentary statement. So the person asked him why. He said that every half an hour, same issue before 16 Supreme Court courts, my lord, if you have the same matter on the same day, 16 judges will give 16 forms of judgment. So, my lord, never knew that today morning I will come and confront my lord with this issue, because, my lord, I'll show at least 3
Whatever any
judgments
proposition under the sun you say,
next
I'll
morning.
give you a judgment for that. That has been happening since long.
This is something unfortunate. My lord, kindly take section 16, my lord.
Yes.
My lord, see is the language now of section 16. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections. It's very wide. Any objections with respect to existence. He is complaining of existence or validity of the arbitration agreement. And for that purpose, now, my lord, an arbitral clause which forms part of the contract shall be treated as an agreement independent. Now, my lord, kindly comes to 2. The plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. He's already filed his statement of defense. However, this is the wider part which is given to him. However, a party shall not be precluded from raising such a plea merely because that he has appointed, I could have also raised, or participated in the appointment of an arbitrator.
Did not participate.
He has. He's filed a
Technically, he did
statement of defense. He's
No,
filed
the appointment of
No, the next part is for him, or participated in the appointment. It's been served. He has not.
He has not participated in the appointment of the arbitrator.
He has not appeared. That's his choice.
Yes, so therefore he did not participate.
It's not a question of participation. It's a question of choice. If a litigant after service does not come forward, my lord, that is to his own peril. He cannot take advantage of
That's a deemed service. That's a deemed good
No,
service. But
not
we
deemed
cannot
good
say
service.
participation is an active role.
Let us.
It's not a passive role.
Let us forget that, my lord. Even then, the scope for him is to go before the arbitrator, because he's challenging existence or validity.
Yes, one is there.
Now, my lord, comes to 4. Why has he come before my lord? Because lordship is hearing not a section 11 for a pre-referral stage. My lord, this is very important. Lordship is hearing a recalling of a section 11, little unheard of. He has got the remedy elsewhere. Now, my lord, kindly sees 4. Why he has done this? The arbitral tribunal may. So the discretion lies with the tribunal. in either of the cases referred to in subsection 2 or subsection 3, admit a later plea if it considers the delay justified. So he chooses this path, which is better. But the discretion is with the arbitrator. Lordship cannot, my lord, enter that domain. He is not a person who is saying that there is no agreement. He is saying that the agreement is a product of fraud. So that domain, my lord, Lordship will not enter upon.
He says there is no valid agreement.
Valid agreement, correct. So, my lord, kindly sees the language, existence or
Yes.
validity of the arbitration agreement. First sentence of section 16. First sentence of section 16, and this is not a, my lord, litigant who was not aware of the proceedings. He goes and files his statement of defense even. I'm sure, my lord, I'm not participating in the arbitration. He has taken these points in his statement of defense. I'm sure that's not disclosed before my lord. So, my lord, if lordship now today, in a recalling of a section 11, which is, my lord, a very tall order, in a recalling of a section 11, considers now existence and validity of an arbitration agreement of a section 11 application which has been moved upon service, there is an order correction upon service. Now, my lord, that I think is too much to, my lord, call for. Because he has already filed his statement of defense.
There he must have taken this point also.
Of course, my lord. Of course, he's not disclosed it. Now, my lord, kindly comes to the law as far as...
No, therefore, Mr. Banerjee,
Yes.
if I heard,
Material which
I mean,
my
if
learned
I
friend is
understood you
referring
correctly,
This material may be given to us also, what he is referring to, and filed before the honorable court.
what material?
Actually,
Not
my
yet
lord,
filed.
here is
We
the
have not
statement
filed
of...
because
Here is the statement of defense filed before the learned arbitrator.
my document I'll deal with.
I am not aware, my lord, somebody
You
else
don't know
is
whether this
appearing.
is that document.
No,
But
no.
this-
My lord,
because
this
they
is-
have done this previously.
I'm
They
sure...
have done this previously.
I don't know, but I'll take
They have given a
instructions.
different agreement before the NCLT.
Yes,
Yes, I will take
maybe,
instructions.
maybe.
Mr. Banerjee doesn't know whether this is the right document. His
Maybe
client
you're putting
knows.
on affidavit.
Give a copy, give a copy to him.
Yes, of
Just
course.
give me
my
a
lord.
copy. That's all that I'm saying.
I will always give him a copy, although he didn't give me a
Mr.
copy of the
Banerjee,
judgment.
your argument that 16.4 is the reason why they come now may not be correct, because in the statement of
I am
defense
on
itself they have already
16.
filed.
I am on 16.1. I am on 16.4.
No, 4, that stage is over because they have filed a defense taking this point. So 4 is not necessary for them.
No, they can still do it before the arbitrator because, my lord,
They have done it in the statement of defense. So
But-
already done it.
no,
So 4 does not come in.
I am saying a section 16 is still maintainable before the arbitrator,
Very.
considering the, my lord, amendment which is coming under 4. Because the arbitrator can still consider
Mr.
condoning the
Banerjee,
delay.
probably the language subject to correction by you, the
Yes, ma'am.
language of section 16 does not mandate an application. A plea raised.
Correct.
So on that statement of defense,
Right,
which has
right,
already been filed, they
absolutely.
can raise that plea.
Absolutely.
They're not barred by 15.
Absolute, absolute. Only thing, my lord, this argument that is making of limitation, he has to just make it before the arbitrator. He, in his own discretion, will
He
not.
does not have to make it. He's in a better position there because his statement of
course.
defense is already there.
Of course, my lord. Maybe.
He had taken an unnecessary risk. I mean,
So, my lord, I am saying
yes.
this statement of defense has been filed by them. I'm sure, my lord, now he will not say authorized signatory director Harsh Shah is not his person.
How do you know?
But I don't know. He can again say that also. This should have been disclosed before the honorable court. Now, my lord, kindly sees, my lord, apropos this, it is too tall an order that he is asking for today in a recalling application before, my lord, in a section 11. Now, my lord, kindly sees the law. Even, my lord, this is now, I feel after this, it is very academic now on a Friday morning. Because, my lord, the law with regard to fraud is well settled. Well settled. He's showing 2 bench judgments. I'll show a 3 bench judgment of the Supreme Court binding. My lord, kindly comes to Arbitral 2 paragraphs only, which has settled the law, where, my lord, fraud cannot be looked into, which he did not read out. Paragraph 34 and 35.
Avital, do you have a copy? No.
I have no copies of what he has given, but, my lord, I can only take my junior's copy, my lord. Mr. Thakkar never used to do earlier. Nowadays, he doesn't give me a copy of his judgments. Which is not actually. My lord, kindly takes paragraph 34, my lord.
I'll hand over.
দিয়েছিস তো
Copy দিইনি, Judge sir.
হ্যাঁ,
বই
No,
দিয়েছি।
copy
ও,
book
বই
was
আছে,
given.
বই।
Thank you.
Might be slightly marked, my lord.
No, maybe, but I'll then retain this copy because that's it.
Kindly ignore the markings, please.
No, thank you for the markings. Yes.
My lord, give me one moment, my lord.
Yes.
My lord, kindly comes to paragraph, my lord, the two important paragraphs, paragraph 34 and 35. And I'll show my lord's judgment also of 2024 on this issue.
No, Supreme Court is there.
No, I will come down from Supreme Court to my lord. In a recent judgment
Yes.
reported as Rashid Raza, which he was trying to show, this lordship has got 34.
No, give me half a minute. There are sub-paragraphs from other judgments, so those are on
Yes, it's
similar.
a quite a longish judgment. My lord.
No, 34 is it. I found out. Yes.
It starts with, my lord, in the recent
Judgment of.
in a recent judgment reported at Rashid Raza in this court, referred to in Justice Sikri's judgment in Ayaswamy, and then held, the principle of law laid down in this appeal, this is again an extract, my lord, make a distinction between serious allegations of forgery, fabrication, kindly will mark, my lord, the word which is complaining of, in support of the plea of fraud as opposed to simple allegations. Two working tests laid down in paragraph 25R. Does this plea permeate the entire contract and above all the agreement of arbitration, rendering it void, or whether the allegations of fraud touch upon the internal affairs of the party inter se, having no implication in the public domain? This is very important. Now see, my lord,
One is applicable. One.
it won't be. Kindly see, my lord, 35 now.
Hmm.
After these judgments, now this is a finding. After these judgments, it is clear that serious allegations of fraud arise only if either of the two tests laid down are satisfied and not otherwise. The first test is satisfied only when it can be said that the arbitration clause or arbitration agreement itself cannot be said to exist in a clear case in which the court finds that the party against whom breach is alleged cannot be said to have entered into the agreement relating to arbitration at all. He's not made out such a tall case before, my lord, because he's already filed a defense. He's already filed a defense before the tribunal. This is, again, my lord, I'm saying not a pre-referral stage, a recalling lordship is hearing. Then, my lord, the second test can be said to have been met in cases in which allegations are made against the state or instrumentalities of arbitrary, fraudulent, or malafide conduct, thus necessitating the hearing of the case by a writ court in which questions are raised, which are not predominantly questions arising from the contract itself or breach thereof, but questions arising in public law domain. So neither of the
Mr.
two is
Banerjee, I'll just
Yes, ma'am.
request you to stop for 1 minute and just let me clarify one question.
Yes, ma'am.
Now, second is not applicable here.
Yes.
34, now the para 35, the first test,
Yes.
that says, as you read out, in a clear case in which the court finds that the party against whom breach is alleged cannot be said to have entered into the agreement. So you have stressed clear case and entered into.
But they,
Clear case I'll be presently coming. Entered into the agreement, doesn't it relate back to para 34, this Rashid Raza 1, that forgery fabrication, which permits the entire contract and the agreement of arbitration, rendering it void.
then
So
there has
forgery renders is
then
void.
there has to be a criminal, my lord, complaint at least against that. There is nothing here. Clear case means lordship in a section 11.
Clear case is yes.
Clear case in section 11. Lordship is not here in section 11. This is not a
But
pre-reference
can there be a
stage.
clear case of forgery? I mean,
Of course, my lord, it can be.
give me an example. I mean, nobody
My
will
lord,
admit forgery.
He comes with, my lord, two documents. One is the agreement on record.
Yes, he's doing
and-
that. He's saying that NCLT filed one agreement, another agreement has been filed here.
My lord, this is
This is his case.
my lord. Let me clear this out.
Yes.
I can understand he has to jump up, my lord. That is different, my lord. But this could only have been done at a pre-reference stage. We are not at a pre-reference stage today, first of all. Secondly, my lord, this domain is with the arbitrator. Lordship, my lord, cannot now enter into that domain at all. The law does not permit it, my lord. This clear case that he is saying, my lord, let us take, I'll give a very clear case. My lord, all that he has to do is bring a certified copy from the bank showing his signature and the signature in the agreement before the arbitrator. This is a clear case. How will lordship in section 11 have a clear case? Lordship cannot put somebody in the box and examine. Cannot do that, my lord. That scope is not there. It has to be a dead wood. Now, my lord, existence is something which can also be looked into by the arbitrator. It's not, my lord, he has to come before my lord to show a law that, my lord, arbitrator cannot do something. He is forbidden under the act.
Particularly at the recall stage of the section 11.
Yes.
If it was, I mean,
But pre-reference, I could have understood he is making a very tall argument. He could have made. I
this
would
is
have made
common
that.
ground. This is common ground. Existence and validity of agreement is common ground between section 11.6a and section 16.1. So that is understandable.
Because,
But
my lord,
after he has submitted his statement of defense, we can. Now, what
because,
about
my
the
lord,
30 days?
because my lord, I'll come to that. Why? Because the scope of the act today
Yes.
is that non-interference of the court.
Yes, yes. It's very clear. And that is one of the.
Non-interference of the court. And this is a litigant who has filed a statement of defense. I would have understood, my lord, somebody, a villager who has not heard about arbitration, not participated. He has participated. He has filed a wakalatnama also before the arbitrator.
Otherwise, he could not file a statement of defense. How could
No,
he
no,
file a
that can be also forged, my lord. I don't know, my lord.
No, it's their document. Their documents won't be forged. Your documents are only forged.
No, no, my lord, this is not.
And understand the situation.
Agreement is a document between both the
The
parties. not
copy
my
which
document.
copy of his purported copy of his statement of defense which you are handing over may be forged.
Yes.
It may not be his, but his original statement of defense is not forged.
My,
That is
I would understood, my lord, my client preparing a statement of defense, my lord, taking the points of non-maintainability is little, even taller than what he is arguing.
no, Mr. Taka has not argued that. I'm putting
So
words
that,
into.
but I'm saying it. That, my lord, that product.
But what
was
about the
forged.
30 days?
Yes, 30
that
days, my
window,
lord,
yes.
I can
Whether the section 11
only-
window could be opened.
Yes. Now, my lord, I can now, my lord, show the other judgments also. This 34-35 is upheld by the 3-bench judgment, my lord, in my lord Vidyadrolia. This portion. So therefore, my lord, this is binding on my lord. This is binding, my lord. That, my lord, lordship will find in Vidyadrolia, this paragraph is upheld. My lord, gives me one moment, my lord, I'll refer to
Just give me the paragraph of
yes,
Vidya.
yes, my lord. I will, my lord.
Was it placed by Mr. Thakur? Probably placed by Mr. Thakur.
Mr. Kedia placed it, my lord. It
Yes.
fits with
I'll
the
just
earlier, the
refer to
opening,
the
my lord.
paragraph.
Paragraph 73 at page 71.
Yes, right.
I'll hand over the book, my lord. I'll
Yes.
just get copy.
My lord, 74.
এটা তো
Kindly
তুমি copy
sees
দেবে।
73,
Inside
74
করছো।
were placed. So he started with Vidya.
আমি তো দিয়েই দিয়েছি।
Yes, very well.
74, lordship will see, if I may read, the judgment in Avital interprets section 17 of the Contract Act to hold that section 17 would apply if the contract itself is obtained by fraud or cheating. Thereby, a distinction is made between a contract obtained by fraud, post-contract fraud, and cheating. The latter would fall outside section 17 of the Contract Act, and therefore remedy for damages would be available and not remedy for treating the contract itself by void. This is 74. Now, my lord, kindly comes to that paragraph. যেখানে বললো এটা upheld করলো এটা তিনটে judgment এটা নয়। Now, my lord, kindly comes to 73. The recent judgment of this court in Avital has examined the law on invocation of fraud exception in great detail and holds that N. Radhakrishnan as precedent has no legs to stand. We respectfully concur with the said view and also the observations. Kindly mark this. Paragraph 34 of the judgment in Avital, which I read out, which quotes observation in Rasid Raza. So, my lord, it upheld, my lord, the judgment in Avital. So, my lord, therefore, my lord, the scope is with the arbitrator. Now, my lord, kindly sees, there is the latest Supreme Court, which has not been reported. It's from the site, which I'll give a copy, my lord. I'm very sorry. This is, this is on the site, my lord, the Managing Director, Bihar State Food Supply Corporation versus Sanjay Kumar.
Handed over this, man. This is
Yes.
the latest on the subject.
Now, my lord, this
That was handed
kindly
over.
takes.
That has been handed over.
তুমি এটা
Yes.
কপি দিচ্ছ না?
না আমার এটা তো তোর কপি আমায় দেওয়া উচিত দিসিনি আমাকে
No,
এখান
it's
থেকে- He has not given me a
2025
copy.
2025 SCC online SC 1604.
Yes, my lord, now here also kindly considers, here also, my lord, these paragraph, this paragraph 16 kindly sees, my lord. My lord, kindly sees the distinction here. Kindly takes paragraph 16 once. Why I'm saying, my lord, this is not available to my lord.
Yes.
Kindly sees, my lord. By way of the impugned order dated 3/7/2020, the High Court allowed all the Section 11 petitions. So, Mala, this is an appeal from the High Court order. This is not a judgment is showing where a recalling is being heard by the High Court. This remedy he has got. He had, in fact. Now kindly sees the High Court held that it is
Just choosing the softer target.
yes. Even Malot, I think Malot, I don't know who is the arbitrator. I think he is also quite tough. I
He's also.
I don't know. I don't know.
No, we would comment on that. Let us proceed.
He's chosen even a softer target.
Yes.
The High Court held that it is undisputed that the agreements, including the arbitration clauses, were entered into freely by both the parties.
This is
And
not applicable to you.
no. I'm saying, Malad, see the stage, the judgment that he's referring to.
Yes.
He kindly sees the stage, not, Malad, what is being, Malad, heard by my lord. Now, Malad, kindly comes to, apropos this, the, Malad, where the part where they have dealt with these judgments. Kindly comes to. Now, Malad, kindly sees the issues which has been framed. Whether the dispute between the respondent and the appellant arising out of the agreement incorporating the arbitration clause has become non-arbitrable. Lordship has got the issues. In view of the initiation and pendency of the criminal cases. So, my lord, this is close to, although Lordship is not looking into now in a recalling, this is close to a clear case. Now, my lord, kindly sees whether invocation of the Recovery Act by the appellant corporation bars initiation of Arbitration Act, whether Section 11(6) of the Arbitration Act is barred by limitation, whether the issue relating to legality and validity of invocation of arbitral proceedings under Section 11(6) is conclusively decided by the High Court in Sadhana Kumari and Bihar Foods Civil Supply.
Issues 1 and 6, those were placed by.
Now, my lord, kindly sees, my lord, there is a criminal case which has been filed. And in an appeal from Section 11, Supreme Court is hearing. Now, my lord, kindly comes to apropos this. My lord, the arguments are there. Now, my lord, kindly comes to the first principle, which is Roman 5, which is paragraph 21, my lord.
Yes, 21.
Principles governing arbitrability in cases involving allegations of serious fraud. In view of our decision, it is unnecessary to delve deep on this issue, but sufficient to restate the law on the subject. The position of law as it applies to initiation of arbitral proceedings in the teeth of allegations of criminality involved in the dispute, where, kindly mark, criminal proceedings are either pending or to be initiated, is considered in several decisions of this court. In Ayaswamy, this court has considered the matter in detail and laid down certain principles. As the relevant portions of the decision in Ayaswamy has been extracted in subsequent decisions of this court in Amit Lalchand, Rashid Raza, and Avatel, we are of the opinion that our judgment need not be burdened by extracting excerpts from the judgment all over again. Instead, we seek to restate the principles as follows. Kindly now, my lord, mark. Access to justice for enforcement of rights and obligations is assured by the usual proceedings in the ordinary tribunals. It is for this reason that Section 28 of the Indian Contract Act, while prohibiting agreements in restraint of legal proceedings, saves resolution of disputes through contract by arbitration. That's not its case. The conduct of arbitration is governed by the Arbitration and Conciliation Act. The limits of dispute resolution through arbitration are statutorily incorporated in the Arbitration Act itself. In Section 2(3) provides that this part shall not affect any other law for the time being enforced, by virtue of which certain disputes may not be substituted to arbitration. Disputes that shall not be substituted to arbitration have been recognized in a large number of decisions of this court. Of these, for the present purpose, we are concerned with disputes which shall not be substituted to arbitration due
Why are you
to...
consistently reading submitted as substituted?
I'm sorry, Malad. Shall not be submitted to arbitration due to application and operation of criminal laws to the dispute in question. That's not the case before, my lord. Even now, my lord, same sets of facts may lead to civil. This is what fell from my lord. This question fell. Same sets of facts may lead to civil and criminal proceedings. A civil dispute could involve questions of coercion, undue influence, fraud, misrepresentation, For example, and such disputes can be adjudicated at civil proceedings for determination of civil or contractual liabilities between the parties. The same sets of facts could have their correlatives in criminal law. The mere fact that criminal proceedings can or have been instituted in respect of same incidents would not per se lead to the conclusion that the dispute which is otherwise arbitrable ceases to be so. So what Malad is, Malad, this kindly takes the next paragraph. Of
4 gives the justification. Next
Yes.
paragraph gives the justification.
The reason for permitting submission to such disputes to arbitration is well explained in Swiss timing. To shut out arbitration at the initial stage would destroy the very purpose. Now, we are not at an initial stage. He has filed his statement of defense, purpose for which the parties have entered into arbitration. Furthermore, there is no inherent risk of prejudice. Kindly mark this. There is no inherent risk of prejudice to any of the parties in permitting arbitration to proceed simultaneously to the criminal proceeding. Here we don't have a criminal proceeding even. In an eventuality where ultimately an award is rendered by the arbitral tribunal and the criminal proceedings result in conviction rendering the underlying contract void, the necessary plea can be taken on the basis of the conviction to resist the execution enforcement of the award. Conversely, if the matter is not referred to arbitration and the criminal proceedings result in an acquittal, and thus leaving little or no ground for claiming that the underlying contract is void or voidable, it would have the wholly undesirable result of delaying the arbitration. Well, after this, I don't think I need to show anything
Mr.
more.
Thakkar sought to distinguish between a fraud, forgery, which vitiates the clause itself.
Yes.
Because then the arbitrator won't be clothed with jurisdiction in the first place. There would be no valid existence of an arbitration agreement. And some other fraud, other allegation of fraud in transactions between the parties.
Now, my lord, here in this case,
But
here,
probably, yes, you have placed the other
here in
judgments
this
also.
case, the court explains, even if there is a criminal proceeding, there is no reason to stop, my lord, the arbitration proceedings. Because, my lord, conversely, if
And
my lord,
particularly in view of section 16(1),
yes,
which confers jurisdiction on the arbitrator himself to
yes.
decide this also. So, very good.
My lord, therefore, I don't think, my lord, after reading, my lord, 4, there is any reason, my lord, for my lord today to re-enter the domain which the arbitrator itself can. Or all that he needs to do is agitate these points before the arbitrator. The arbitrator will adjudicate these disputes before.
What about the 30 days? Come
Yes.
back to
Now, my lord,
Now,
let's just come to the facts.
this is regarding fraud and all. Yes.
Yes. Now, my lord, kindly sees, my lord, the 30 days. But I'm not showing my lord's judgment on this. Lordship has dealt with
On
a
the same
similar-
point, then don't repeat.
No, lordship has dealt and said that this should go to the domain of the arbitrator.
Leave it. Yes.
Because lordship has recorded these
One
things.
tends to follow one's own judgments, and
Very, very,
it's
very
ridiculous when you see relying
No,
on a
it's-
previous judgment and you
it
go and
is
look at the judgment, some interesting proposition.
It is
So the same judge has
It's a
repeated.
2024 judgment of my lord where same plea was
Supreme Court
taken.
is there, so no difference.
Same plea was taken in section 11 stage itself. And lordship has said, no, this is under the domain of the arbitrator today. You have to go before the arbitrator and agitate it. So may I?
I'll re-adjudicate in this matter. Yes.
Very well.
Regarding that 30 days. Yes.
Yes. Now, my lord, the 30 days, my lord, I'm not filing the opposition. May I just, my lord, if your lordship
So
wants,
you
I
just
can.
indicate if necessary, I'll direct you to put in affidavit on
My lord,
this. Because I'll
page
That which I've heard.
24, or I have not filed the opposition.
The
So
page
lordship will not be able to see it.
achha.
The last time
You-
they said they do not want to file.
I do not wish to, because, my lord, this is such a straitjacket case, my lord, I do not wish to. But
And
since
the
he has taken, my lord, on the 30 days issue, I must show to my lord, may I just say and then, my lord.
Opposition, my lord, if I need to, I'll take time to file a reply. Otherwise, I will not. I will not
Lord,
delay
may I
the
just-
matter any further. Let him file.
You're ready with your opposition?
Yes, yes, I have a affirmed opposition with me.
I
May
will not
just
say that he's
indicate-
Did I record that he has?
Your lordship remembers my
I-
learned Prince Junior was there. Your lordship
Yes.
inquired. He said, yes, I am being advised. My client is advised not
Oh, yes.
that matter.
I-
Then I inquired of him. He said, yes, we
Yes,
don't.
yes. You said don't take the risk.
I told him, don't.
This-
So let him
30
file it.
days-
I'm not coming in the way of that. He'll
Understood.
change his mind.
My lord,
But
I don't
if-
need to
if-
change my mind, my lord. This 30-day issue cannot be raised by a person who has filed his statement of defense and suppressed it before the court. Let us not, my lord, change my mind. He should change. His client should change his mind to come clean before the court. Now, my lord, kindly sees, my lord, if I may just read out. My lord, lordship feels I'll otherwise I won't. There is, my lord, a document, my lord, a mail sent on 31st of July 2024 to the mail ID that they, my lord, have.
These statements made from the bar, my lord, tend to weigh on your lordship's mind. Let him file it so I can deal with it. Let him not make statements, my lord.
But
Then let him, if
today-
he doesn't want to make statements which are not
my
on
lord,
record, let him not make.
My lord, today I make this.
Let
put
him
this
file it.
question.
I will deal with it.
Today, my lord, I
Here and
put
now.
this question. My lord, will your lordship, my lord, enter upon this domain again?
Don't make these submissions. Then say
So he is taking this point, then lordship will not consider this point of my lord 30 days and all. This is my lord.
No, what is the
lordship-
date you are saying?
My lord, this is a mail of 31st of July 2024.
31st of July 2024.
This was filed in the non-commercial division. That is exactly what I'm saying. So 30 days is long over. This was filed, my lord, 31st of July
So
2024.
this section 11 was filed on 23rd of July 2024. That is what Mr. Thakkar says.
It was affirmed.
When was it filed? Same day filed.
But probably the next day or something, my lord, around the same time. Around the same time.
So even if one day after it is within 30 days. So this section 11, which was allowed, that was filed on
My lord,
23rd.
this document that I'm saying, 31st of July 2024, this is for the earlier section 11 which was filed, which was 23rd of July 2024.
23rd of July 2024 is the section 11 which I heard and decided.
No. That's exactly what I'm saying. What lordship has, my lord, heard and decided is the application which was withdrawn, file in the commercial division.
23rd of July 2024, section 11.
My lord, is 2nd of September 2024.
Yes.
So what has happened? Initially, it was filed in the non-commercial division.
Right.
Let us take, my lord, then 30
So
days
on
was not
23rd of
over.
July, it was in non-commercial. Then,
It was withdrawn.
is there a formal order permitting you to withdraw?
Yes.
What is the date of that?
2nd of September 2024, on the prayer of the learned counsel for the petitioner, leave is granted to the petitioner to take back the application and file it in the commercial division of this court. So when I file the commercial division, 30 days is long over. Admittedly.
Mr. Thakkar, probably this will be on.
And my lord,
these are the orders.
I'm hearing a whisper service. Let me now show the service.
No, I'll look into only that September 2nd, 2024 order, which is available on the court's website.
Yes, my lord. I will stand corrected because those were my instructions. Now, if he shows the service, because I was under the instruction that
Yes.
the 23rd July filing, because the 23rd July came to me by email. I
Yes.
saw that and I came to court saying 23rd July filing.
2nd of September 2024, you must not have been present.
I-
Or you,
I was not present
You
then
will be present
also.
on-
I wasn't not present then, but my ground has been taken on the basis of the 23rd July email, which the service of the 23rd July application. Now, if he shows that on refiling in the commercial, it was served, then, my lord, then the second filing may be correct because if it's past 30
Mr.
days.
Thakkar's, my lord, will be surprised on a Friday morning. Like just he was surprised with the defense. That was also not instructed to him, I'm sure. Considering Mr. Thakkar,
you're not instructed. Then.
Defense was not interested. They pointed it out on the last day.
Statement of defense, my lord, also he
Okay.
got surprised. Anyway, my lord, so 2nd of September, lordship gave my lord liberty.
Can you just give me the date of the fresh
Okay.
filing? The
First,
2nd September.
my lord, around that time, my lord, first file.
The learned junior is very sharp. I mean, he
Yes,
might know.
it would be around July 20. July, my lord,
No, 2nd. So it's 2nd of
Second
September
filing.
2024. is-
second filing would be around, my lord, September 13 or September 12, 2024. Because we have served.
for the records, yes.
Yes.
So in
Now, my
September, obviously.
Now,
Yes.
my lord, that AP number was 140 of 2024. The earlier one, which is dated 2nd of September 2024.
AP 130.
140 of 2024.
Yes. And the second?
Order dated 2nd of September 2024. Lordship giving us liberty.
Yes.
Now, my lord, I go back.
And what is the
The new, my lord, AP number is 824 of 2024.
yes.
APCOM. And, my lord, the service.
Yes, yes.
Now, the service was made on 12th of September 2024 at 10:37 on the same mail ID. So, this is been filed much after the 30 days.
Service of that second section 11.
Yes, yes, my lord. Yes. On the same mail ID.
No, if the filing is after, then the filing comes after 30.
Absolutely, my lord. Absolutely, my lord. So, this is much after 30 days. So I don't think, my lord, I need to file an opposition, my lord. If your lordship wants, I can.
No, I'll look into only the September
Yes.
2nd, 2024
And
order.
then, my lord, kindly sees this is 12th of September 2024, 10:37. My lord, to the same mail ID. Now, my lord, kindly sees it.
That is not necessary.
And, my lord, he says, my lord, something happened. This.
See, regarding the service of the second section 11,
Yes.
because there must be some finding in the original order which is
My
under
lord,
recall.
affidavit of service is on record.
Affidavit of service is on
in the
record, and
AP.
unless
Lordship
I
will call
hold
for-
specifically that it has been served, they don't appear.
Never
I won't
possess
proceed to
it.
pass an order.
Exactly, my lord.
So
Now,
that presumption can be drawn from that was served.
kindly call for the records.
But
that
Mr.
will
No, Mr.
not look
Thakur's
into, my lord.
point is different. That 30 days was not over when.
Now it is over, my lord. Now, my lord, let me I am not, my lord, saying, but let me show, my lord, something, my lord, which is, my lord, I've seen the name. He is a much tougher guy. So, my lord, let me show now the arbitrator on 2nd of January 2025 has intimated him. What is he saying, my lord? It was addressed to us. It was served on him on 2nd of January 2025. So, my lord, why did he wait till today?
Yes.
Now, my lord, this order was mentioned for rectification before, my lord. Now, that we served, hello, service kobe korechu? 9th of January 2025. This was the mentioning notice given to them. Upon the mentioning notice, lordship being satisfied, lordship has passed an order again on 17th of January 2025, since they chose not to appear. My lord, changing, my lord, there was a correction in the name because it became Ghoshal instead of Ghosh.
Yes.
I don't think, my lord, we should. This was also served by a notice dated 18th of January 2025 at 13:13 hours. Mr. Thakkar has not been told a lot of things, but my lord, these are records. These are records. But I don't need to file anything. Lordship will call for the section 11 records, my lord, which is part of the records of this honorable court. Lordship will see the affidavit of service. These are, my lord, I'm saying, my lord, if he goes to this extent, I can go to a more, my lord, a greater distance. There's a correction made, lordship's order dated 17th of January 2025 upon notice to him on 18th of January 2025. And, my lord, these are, my lord, post 30 days. So, my lord, I need not, my lord, dwell into all this. 30 days period as far as the order against which he has come, my lord, was over.
Good.
So therefore, my lord, the limitation part also, what he's saying, my lord, recalling limitation will only come when recalling is maintainable. But I'm saying it is not even maintainable because his remedy is before the arbitrator. Now, my lord, apropos this, my lord, when he has filed his statement of defense, he has, I'm sure he's taken the points in his statement of defense. It is the domain of the arbitrator, my lord, to deal with. I have not shown any judgments. I've only shown the portions from his judgments only, which is also
That's both ways, because if he has filed the defense and taken this point, then it can be decided by the arbitrator very well. And if he has not taken this point, he cannot be permitted to bypass indirectly what he did not do before the arbitrator. That logic may be given by you.
Correct, my lord. And, my lord, I am not. Oh, he has. Paragraph 4, my lord, of the statement of defense, he has taken this point.
Must have taken. Must have taken.
Only point taken.
Yeah.
Paragraph 4, paragraph 5. Yes,
Great candor on your part. No, very well. We must have taken.
So, my lord, I am not getting into it, my lord. This application, as I said, my lord, on the issue of maintainability, my lord, it's not maintainable before.
So now it will be somewhat extempore for Mr. Thakkar on 2
No,
points.
lord, all that I want, my lord, is that, my lord,
Let us see debate
Judgment.
skills and
the
extempore
judgments which he has shown.
jam skills. Just a minute.
My lord,
If he's concluded then.
he might have a lot of skills, my lord,
Mr.
but
Banerjee, you are mandated by the court to conclude within 2 minutes.
my lord, I will, my lord. I will not take 2 minutes, my lord. I'm only saying, my lord, he might have a very good oratory skill, but I'm sure lordship is bound by the law of the land.
On this, we will hear you somewhere else.
No, I'm not, but I'm saying, my lord, I'm sure lordship is bound by the law of the land. So, my lord,
Yes.
I don't think, my lord, that would have an effect. But all that I'm saying, my lord, the judgments that he is showing is also, my lord, appeals from section 11. That scope he also had. That scope he also
That
had.
recall point also, right? That is another point you've taken.
So I wouldn't say, my lord, this is a litigant, my lord, who is diligent. This is a litigant who is trying his hands in different forums. And my lord, he cannot here because the arbitrator is in season of the matter. Lordship cannot enter upon this domain. Otherwise, it will open a floodgate in every matter.
True.
Well, those are my submissions. I have not taken 2 minutes.
That's why I said true.
30 days argument is not answered. Kindly see.
What is this?
This is the case status of the High Court relating to APCOM 842 in which your Lordship's order was made. It seems that they realized before they withdrew their regular division matter, they had filed the commercial division matter. Kindly see. The filing of APCOM 824 of 2024 in which your Lordship made the order, kindly see is registration date 23rd July, filing date 23rd July, not after they had withdrawn the regular division. So the 30-day point, there is no answer. There is no answer. So it's a jurisdictional fact. The order is a nullity. The order is a nullity.
My lord,
It's
may
a
I just
jurisdictional error.
may I just interrupt once?
Should have been
May I just
satisfied.
interrupt once, my lord? This is a very serious issue. Mr. Thakkar is saying without even calling for the records.
Yes,
Lordship will kindly call for the records.
Let's call
Now, my lord, I stand up. Lordship will call for the records.
Let's call for
This is, my lord,
I am
thing
going
which has
by what
not
the
been
High Court
uploaded.
is saying. I'm
Kindly
clear.
call for the records and then take up the matter.
Correct. Let us pause here.
During hearing,
Because, my lord, I have the document where corrections have been allowed. My lord, I don't know how is this being instructed. My lord, kindly checks the records. This is very serious.
And-
This is, my lord, website cannot be looked into. This has got, my lord, I can
an
show
issue
lot of submission, my lord, lot of recordings which are wrong.
arisen as to whether the application under section 11 of the Arbitration and Conciliation Act 1996, from which the present recall application arises, comma, that is AP within bracket com 824 of 2024 was filed within 30 days from the issuance of notice under section 21 of the said act or subsequent thereto. Full stop. Next para. Since learned senior counsel appearing for the petitioner contends that APCOM 824 of 2024 was filed on July 23, 2024 itself, comma, that is the date of filing of AP 140 of 2024.
AP 140.
480, the second.
That is, both are of
Not
23rd.
First, what he's showing.
My lord, call for the records for both.
Yes, yes, I will.
Kindly, my lord.
Kindly
Acha,
since
that is the date of filing of AP.
that is I don't know.
Which-
That part I don't know.
Comma, which is controverted by
40 or
learned senior counsel appearing for the respondent, comma, for the sake of clarity, comma, the records pertaining to AP Com 824 of 2024 as well as AP 140 of 2024 be called for
Yes.
and tagged with the present file. আছে দুটোই? দুটোই আছে?
বাহ, ঠিক তো।
সেপারেট কোন অ্যাপ্লিকেশন ফাইল হয়নি?
And my submission is on the basis of the
Mr.
website of the High Court.
Mr.
No, I'm not
The
making
website is sometimes incorrect. That's why.
It's doing now, my lord.
No, Mr. Banerjee, please take instruction. Probably there was no further filing. This দেখো ওনাকে দেখো.
Was
Adjournment.
converted.
Apparently that was converted.
I'll just check once.
My lord, kindly sees, my lord, this was taken back. This was taken
And
back.
refiled.
Corrections
Represented.
made. My lord, kindly sees the date. 11/9/2024 at the top. That's the date lordship has to look into. That's my lord, given by 11/9/2024. That is why I said call for the records.
This is the only records we have.
Exactly, my lord. The records will speak for itself, my lord. This is not scribbled by us. 11/9/2024.
এই ছাড়া আর কোনো তো রেকর্ডের ব্যাপার নেই।
There is no other
এই
record.
অর্ডারটা কেটে এই অর্ডারটা কেটে হ্যাঁ কেটে কেটে। So whatever is there, it's just both
Exactly.
of you please take a look at this.
Yes, my lord.
এটা একটু হ্যান্ড ওভার।
This is what my lord shows from the website also.
The website is not up, my lord, corrected. It is here, my lord,
Person is
11/9/2024.
The person is before you while you look at the photograph.
Yes.
The
So, my lord,
earlier date is 23/7, above date is 11.
Sir, Thakkar, apparently that is
This is the first way
you
to
know, I mean,
AP
your learned junior will know better probably because
Yes.
regarding the filing.
So, my lord, this is
or
filed.
or your filing advocate will be knowing still better.
So AP 140 of 2024.
It was presented on 23rd of July 22 না এটা না অর্ডার হয়ে গেছে এখন কিছু
The
অর্ডার দিচ্ছি
application was filed on 20.
পুরো কেটে দাও পুরো কেটে দাও, মায়া করো না
140 was filed in
order এ
July,
কত-
this was in September.
AP 1.
filed first on 23rd of July 2024, which
Correct.
is the filing date shown.
Yes.
Then that order of 2nd of September
September.
2024, you can file from the website
And
itself.
then we filed on 11th of
Then it was
September.
refiled on 11th of, because that is the date when that new number was allowed.
Yes,
That is on transfer of proceedings
date of
from the
file.
original division to the commercial division.
Yes.
The application is, there is no re-verification. The affirmation is of 23rd July 2024.
Hmm.
So that is why I took the point, because I went by the service which was made of 23rd
But the
July.
AP number, it was stillborn in a sense.
Exactly.
The application was on that date of 23rd July 2024 is the application which was carried forward. It is not a fresh application which was filed.
If it is not a fresh application, my lord, renumbering was not required.
No,
Because it's in a different
not that-
division itself.
Yes.
It's a division itself. And my lord, the
No,
date
Mr.
is 11th of
No,
September.
even on the appellate side, Mr. Banerjee, what happens? FAT number is given erroneously on the basis of its FMAT. It should be FMAT. We direct it to be renumbered, reclassified. It's done, but the date of filing remains the
But
first
this
file.
is not the same, because here, my lord, we are
Different
transferring.
division, different division.
Yes, different division. And then, my lord, the date
Have
of
you got a copy of, can you find out the a soft copy even, or just something? That order dated September
Yes,
2nd.
I've got a copy.
Just give me a copy there. ওটা দাও। That order will be very crucial.
Leave is granted to take it back. And that is why the date is 11th
এটা
September.
Mr. Thakkar কে একবার দেখি। Whatever physical process was adopted, Mr. Thakkar, it's for all practical purposes a refiling. Withdraw and file afresh.
The discretion is that, my lord, the court transfer,
That
but
is
it
what-
is renumbered because it's a new application.
Yes.
Otherwise, lordship would have passed in that
Physically, it
only.
might have been the same application, but it was in terms of the leave granted to withdraw and
File it
file
in
afresh.
in the commercial
Mr. Thakkar,
division.
you have to consider that also. Because it has to be
On
rated.
the basis of the affirmation.
No, you're right. You're right. And I also I was
23rd July.
taken aback when I saw that that is the only application which
And
is
that
there.
is why I
No
said,
re-verification, as you rightly say, everything.
that
but-
is why I said call for the records, ma'am.
It's like an amendment when we direct them to amend. Then order 6 rule 18 would come in or not. If they are directed to file an amended plaint and the court is directed to, it's something of that sort. The department treated it to be, like this. This was the modus operandi or adopted by the department, but it has to be read in the context of the order passed.
Order 7 Rule 10 may not adjust. This is akin to Order 7 Rule 10. It is akin to Order 7 Rule 10
Yes.
to what happens when the plaint is returned with the leave to file afresh in the court having
True.
jurisdiction. It is somewhat
But
akin to
that would
but
be going a bit too far because Mr. Thakkar, we are still,
because what is the filing date then
yes,
of the old? Because there is some law on that.
withdraw and file afresh.
There is some law on that, and there's a
That is-
body of law on that as to what is taken as.
Withdrew and file afresh, file afresh.
And that is why it's renumbered. That
And
is
on
why
that
there's
it is
a
the
same
number
date,
has been
and the date is also given.
What is taken as the, my lord, purpose of limitation, etc. law.
I'll consider whether this is a fresh filing or
Yes,
that is a date.
that is the filing.
And what is your reply to the other?
My lord, on the
I will come back on the issue of fraud.
not my, I just take 2 minutes. The judge,
Now, yes,
yes,
if you can finish in 2 minutes, then no.
yes, 2 minutes, my lord, because I don't need to elaborate on this.
একটু
The
দাঁড়ান তো,
first
একটু
argument is all the judgments are at the section 11 stage, not at the recalling stage. That is neither here nor there. The recalling
In appeal against section 11, he says.
Not appeal against section that is
The recall scope is limited. That is what he says.
recall scope is if the recalling is allowed, everything is heard afresh. And against an ex parte order, a party has 2 options, either
Yes.
recall or appeal.
Right.
And it's not said that the scope of recalling is less than the scope of this. So the
My lord, I would stand there, my lord, he's making a fresh argument. This is not an ex parte order. This
Reply,
is not
reply.
an ex parte order.
No, this is reply.
The
yes.
reply, but not an ex parte
You
order.
take your seat, Mr. Ban.
This, my lord, cannot
Do
be.
you have a seat behind you?
I-
Give a seat to him.
My lord,
Give a seat to your senior. It's your noble duty. You yourself take a seat. Don't encourage him. Yes, Mr. Thakkar, quickly complete.
30 is one of the remedies and from an ex parte order. Whether it is, that is
Order.
the remedies are.
This is the extempore part.
Order 9, Rule 13, my lord, is available from an ex parte order. As so is an appeal. So if a ground
Don't compare apples with oranges.
Compare
This is just apple and orange. Order 9 to 13
whether grounds exist,
recall is something completely different. And it has been deprecated time and again unless it's a review. I was notionally treating it as a review, in fact. Whether it's an error apparent on the face of record, if it is 30 days.
correct. 30 days now, my lord, on that path, your lordship will consider.
That will have to be considered.
Okay, that's
Whether it's a different filing or
yes, whether it's a different filing or it relates back to the same date.
right.
Second is, my lord, on whether this ground of fraud, the existence of the arbitration agreement. Can you see the last decision which was shown, which is on
That you reiterate your arguments because you're
no, my lord, paragraph 11, what my learned friend placed. Paragraph 16, there was no dispute that the parties had agreed into the agreement
yes.
out of their own free will and volition. And that is why the 11 was allowed. There was no dispute on the entering into the agreement. The minute the dispute is about entering into the agreement, the Supreme Court says that relates to a jurisdictional.
Yes, I saw that. I marked that part that
Yes.
entering into the agreement.
It's undisputed. And that is why I said, Malad, these facts are different, but because the law is summed up here after considering everything, and this is the latest judgment, and subparagraph 7.
Will only be on the law, not the outcome of that.
Yes, subparagraph 7 of paragraph 4 says this is a jurisdictional fact. Now, on the aspect of overlap of 11 and 16, but there is an aspect of
Yes.
after considering 16, all these judgments have been passed starting from Ayya Swami.
In those cases, section 16 stage had not yet come.
It had not come. But
In your case, he says you participated, filed
now, so what is the
your defense.
What is the effect of my filing? What is the effect of
You have submitted to the jurisdiction of the arbitrator. You have taken this point before the arbitrator.
that is the only short.
And section 16, the common ground between the two is existence and validity. That also he has argued independently.
Yes, so my lord, section 16, whether this will amount to submission of jurisdiction to arbitrator, that is the short point. Section 16, if your lordship sees the section itself, see, it does not tantamount to submitting of jurisdiction to arbitrator.
not
because
in-
it's challenging the jurisdiction of the arbitrator. And there the arbitrator
Not submitted to the jurisdiction. I used it wrongly. You have participated in the arbitral process and taken this point in your defense.
Hello, this is not. Kindly now see whether I have made an argument on merit, because that is where the submission of jurisdiction to court also comes in.
No, not submission of jurisdiction in the sense that you waive your maintainability one. Not that. No, you have not waived your jurisdiction point.
No, no.
Mr. Thakkar, what I meant is that you have participated by filing the statement of defense
Great,
and
Malad.
taking this point.
Now-
So why not the arbitrator should decide it?
Grateful, my lord. Whether this filing this amounts to participation, because participation has to be understood as submitting to the jurisdiction of a court or
Not necessarily for a section 16 also you have to participate there and file your section 16.
Correct. Participation as in the physical act of participating by filing is separate, but submission to jurisdiction.
You have taken this point before the arbitrator.
On the merit. Submission to jurisdiction is always when a submission is made on merits. That is why, my lord, section 8 also provides.
You have taken this point, the same objection before the arbitrator in your statement of defense.
Yes, now, my lord, whether that forecloses me from taking the point at the recall before the honorable court. That is the short point. Whether if the court has jurisdiction to decide this point, which the judgments of the Supreme Court unequivocally show that this is a point which can be decided by the honorable court, then merely because the arbitrator is entered into reference and a point has been taken, this very same point has been taken, whether it tantamounts to submission to the jurisdiction of the
No,
arbitrator.
Mr. Thakkar, then might be your conduct would be suspect in the sense that you are trying to explore and forum shop.
My lord, on forum shopping, there are two things. First is, my lord, whether the tribunal has the jurisdiction to decide that this might be held to be a misconceived application, because the court holds in the why the court says that the court will itself decide and not the arbitrator, because it goes to the root of the matter. Justice M.R. Shah's judgment goes to the root of the matter and goes to the existence of the arbitrator himself.
My lord, may I say
The
one thing, my
existence
lord?
of the arbitrator himself is in question.
2 minutes are over. Your arguments are closed. Yeah.
May I say one more
No,
thing?
nothing.
Now, there is one very important document. The person appears in person before the arbitrator. Before this, he has also filed a preliminary reply of all statement of claim where he has taken this point of jurisdiction also. This is the second document they have filed there. I am sorry, my advocate on record gave it just now.
What is the date of this?
But this is, my lord, prior to the
22.
defense. This has been filed now. So, my lord, this doesn't lie anymore.
The defense, your lordship, will only consider whether there is any submission on the
Give a
merits
copy
of the
to him also. if
Yes,
you can.
yes, my lord. He appears in person, so Mr. Thakkar doesn't have all these copies.
Anyway, so
Great.
your reply to that would be the same, Mr. Thakkar.
reply is the same. There is no, my lord,
Jurisdiction
submission
point
on the
taken there
merits of the matter. So that does not, if I had submitted on the merits, if I had made comments on his claim, on the
Yes.
merits of his claim, then it would be a deemed submission to jurisdiction of the
This is
tribe.
not submission to jurisdiction. I
Correct.
corrected myself. It is just that you have taken this same point before the arbitrator.
Now, my lord, whether it's 16
মিনিট তো
existing
হয়ে গেছে
leads to the existence that your lordship will interpret whether existence in 16 is the physical existence of the contract of the arbitration agreement itself. That is what the Supreme Court says existence means the act of entering into the agreement or not.
That is the
where
meat of your
that
contention.
scope is with the arbitrator there, my lord, under section 16 to
Then, my
adjudicate.
lord, if the court does it under the 11th,
This is a recalling,
then
my
there is
lord.
no
This is a
question of
recalling,
the
I think.
16 doing it.
Too tall an order is asking for.
Recall application to report order হচ্ছে heard both sides, hearing is concluded, and the matter is reserved for judgment.
Grateful.
Grateful.
Thank you very much, both of you.
Grateful, my lord.
Yes.
No, no, no. Grateful.
Yes.
Well, these are my applications for setting aside of an award. The award is not in existence. It's a copy of an award which we got.
Oh, that.
That minute. There's a quite. তুমি বলবে?
In this matter, Mr. Bose is leading me.
No. In fact, we had made submissions
Yes.
several times. Dear Lordship may recall, as far as the first matter is concerned, Mr. S.N. Mukherjee was appearing, hearing concluded. The second one, which is
Yes.
more or less, Mr. Bashawat, started, and therefore bench got changed. Your Lordship, then it came back. The point is very short. We have got only a copy of an award. The date of the award is September 2020. During pandemic. Now, the date of the stamp paper, apparently,
This is Howrah was a
no,
not that.
Buro Shiptala.
Yes, Buro Shiptala is in Howrah. It's not in Howrah. Behala Bela. Buro Shiptala.
Buro Shiptala.
No, Buro Shiptala was stressed. No, Mr. Mitra.
New Alipur.
No, just because it's nearer to your residence than the High Court, that does not mean that it's a holy place or second.
May also be nearer to your Lordship's relatives.
I have so many relatives.
And Buro Shiptala is New Alipur.
You cannot pick and choose relatives. But it's you who is concerned.
No. Mine is the other Alipur. It's farther down. It's
Achha, very well.
Chetla.
Yes.
Chetla. If you really want to know, it's Chetla. And that is this that puja thing. What
Einstein, the same happened to Einstein. The same thing happened to Einstein also.
Shuruchi Shongo. Yes, it's nearer to Buro Shiptala is now basically.
One day you'll forget the route to your home.
Oh.
You do. That's deliberate. No, sorry, Mr.
No.
I was just
No.
that Buro Shiptala matter. Yes.
Yes. The award is of September 2020.
Yes.
The stamp paper is of March 2020. The original award is not there. The statement of claim is not there. The minutes of the meeting are not there. Only there is a sort of a when I ask for the copy of the award, I am slapped. I am supposed to be the claimant by the arbitrator. Arbitrator says, "Okay, you will
Not
get
paid."
Yeah, well, I do not have retained any copies. But if but the original you give me, but the original has circulated because I have not paid. So payment of what fees? So he slaps the entire fees on me. Yeah. We also calls for the other papers and etc. and the minutes, everything. So I don't have any minutes. I have returned everything. I said, where's the award? At least you give me, which I will get the award, but you pay, and the entire fees are slapped on me. The letter indicates that.
Yes.
Now, my lord, in the opposition says they are given an opportunity. I mean, they can disclose. They say that nothing is disclosed. During course of hearing also, the award, the original so-called award, may not, because the arbitrator says it could not have reached anyone. Could
just 1 second, Miller, because he said there's no 21 notice. It's there from their end.
No, I have not said
Miller,
about 20.
we have prepared 2 supplementary affidavits. I'll just indicate why, my lord, it took us time. But the concerned person who's looking after the matter, my lord,
Hearing
from our end,
is
I know, my
almost
lord. We're only,
halfway through, more
know.
than halfway through.
my lord, only
Now no
because
supplementary evidence.
only because the notice is there and issued by Shrey.
Well, even if the notice was there, I mean, but at this stage, I
And-
won't permit you to file any further pleadings.
Very well, my lord.
Did I say anything about notice?
But it's not.
If you had a copy of the original award or something,
No, my lord.
then we could have understood.
No. I'll get this.
Yes, distracted.
Very well, my lord.
Complete.
Because we have also written to them.
That may have been a purpose.
No,
Mr. Ghosh knows you very well.
yeah. Now, my lord, so
আরো distract করে দেবো।
Mr. Ghosh, no further distractions. We're not looking into that document.
let's not get personal about it.
No, it's not personal. It's nothing for
Ah,
personal. I'm just saying just for
Don't
distract.
show
No,
that.
not, I'm just not
Don't
at all.
show that.
No, no, nothing of personal. ছেড়ে দাও, রেখে দাও না। ছেড়ে দাও, রেখে দাও।
Now, my lord,
So arbitrator says she doesn't retain anything, and the entire remuneration is made your liability.
yes,
and
yes.
For that
and
reason,
there
no,
is nothing.
no
And
original award.
the opposition, they say, the my lord, that there were 2 days the meeting was held, apparently. May 2020 and July 2020. That's what they say. 2 hearings, if I'm. Oh, and sorry, preliminary hearing of on 15 January 2020. Now, these are so-called minutes, but nothing has been disclosed. So, and in August 2020, I have, my lord, disclosed that they have admitted dues. So even after the minutes, they have admitted dues so far as my 2 contracts in the 2 agreements are concerned. August 2020, and award says nil award in September 2020. These, my lord, are on the question of, it is on the grounds of section 34 that perversity, etc. I'm not going to the procured award or fraudulent award at all. These are on the question, take the, my lord, normal grounds which are available. Offense public policy. Even if you look at the award, not the procurement side or the that it is bad, it is perverse.
In fact, there is no award, you say.
No, that is the second thing. That's a question of whether there is an award, it's a procured award. That's the second. But main thing, take the award. Actually, there is no original award. That takes care of the limitation aspect. My lord, but they disclosed it in an opposition in the NCLT proceedings when the matter ends. When the matter ends, my lord, before the we go out of the resolution process in August, we file a proceeding under section 7, and my lord, immediately they file an opposition where this so-called award is, although my lord, during the proceedings before the administrator, they admit, go on admitting that there is so much liability. My lord, there is, for example, a letter of 7th October 2022 admitting the dues against the agreement. Now, if obviously, my lord, the papers we have shown your lordship.
I'll take a one-page note of agreement from you.
Just prepared. I have already prepared.
Just refer to the page numbers for that only.
Yes,
I
it is
remember the grain of the
page
argument.
107, my lord. We have prepared everything. Yeah. No.
I think I should recapitulate, my lord. Otherwise, the whole thing is. Well, I shall just indicate to your lordship in the form of list of dates as to what has happened. Well, I just
May I take your leave?
with the leave of my learned senior.
Yes.
No, don't.
Yes.
My lord, I shall start, my lord, where we left off on the last. My lord, what happened was this. On 8th October 2021, an application was made by my client. Yes. Oh, sorry. An application was made by the Reserve Bank of India under section 227 and 239(2) of the IB code. Yes. For appointment of administrator in respect of my company, the petitioner. Now, my lord, that was in 2021. Well, upon approval of the resolution plan on 11th August 2023, the administrator was appointed, and my lord, the papers were handed over to him. Ultimately, a resolution plan was approved by NCLT. Now, on 30th January 2023, these dates are important. Petitioner demanded 11 crores 85 lakhs 2,000 in respect of contracts numbers so and so. Well, I am not giving your lordship the particulars of two contracts. And my lord, another notice of demand was issued on the 30th August 2023. There was absolutely complete silence on their part. Nothing has been said. Then, my lord, on 5th September 2023, petitioner filed an application under the Section 7 of the IB Code against the respondent. So, my lord, in that proceedings, for the first time on 25th January 2024, in a reply affidavit, my learned friend's client, for the first time, in respect of this demands of under these two contracts, for the first time they came out with the story of the award, and a scanned copy of the award was annexed to it. And this your lordship will please to find at pages 260 to 278. Yes, at page 268 and 271. Now, my lord, the petitioner came to learn about this award for the first time on 5th January 2024. Yes. Then, my lord, on 19th April, these dates will be important. 25th January, we came to know from their affidavit. And on 19th April 2024, my lord, petitioner made the application for setting aside of the award, alleged to be dated 17th September 2020. And we came to know of the 17th September 2020 award for the first time from their reply. My lord, I have just indicated to your lordship, I have calculated the dates. The date of the award is the date of the knowledge is 25th January 2024, and we have made the application on 19th April 2024. So this will be within the period of limitation. So this was the position. Then, my lord, on the 1st of March 2024, the petitioner wrote to the arbitrator after coming to know of it, of the cause papers of the entire arbitral proceedings. That letter is there on record. I shall come to take your lordship into that. And the arbitrator's reply is very significant. It is at page 347. Kindly, my lord, take that. This is in volume page 347. Kindly, my lord, take this.
347, yes.
Yes, 347. This is the first reaction from the learned arbitrator. Very well. Kindly take page 325. 325 hour later. This is the genesis of the entire dispute. My advocate, my lord, wrote to Srimati Bandana Ray, who was stated to be the arbitrator. Yes. Respected madam, we are representing Srey Equipment Finance Limited. One of the borrowers of our client, namely Roadwings International Private Limited, is in default, and proceedings have been initiated by our client. In a proceeding under Section 7 of the Insolvency and Bankruptcy Code, the said borrower in its reply filed thereto has disclosed two awards dated 17 September 2020 and 21st September 2020, which is stated to have been published by you. For your ready reference, copies of both the awards are enclosed herewith. Since our client has undergone CIRP and there is a change of management, upon such awards being disclosed in the reply affidavit by the borrower, a thorough check has been conducted by our client, but no records of such arbitral proceedings could be found. In such circumstances, on behalf of our client, we hereby request you to kindly provide us with a complete set of entire arbitral proceedings, culminating in the aforesaid two awards, as relied upon by the said borrower. Please treat this letter as urgent. Any cost of issuance for 2 copies of the arbitral proceeding shall be forthwith borne by us. To this, my lord, the reaction was, as I told your lordship, at page 347. My lord, this is a short letter. If your lordship kindly comes to page 347, yes. This is written by the Srimati Bandana Ray, former district and sessions judge, to my advocating record. Subject arbitration between Shrey Equipment and Road Wings. This has reference to your letter number so and so, dated 1st March 2024, received by me on 4th March, wherein you sought certain details on behalf of your client, Shrey. In the said matter, I have passed award dated 17 September 2020 and 21st September 2020, in which it may be noted that following charges as detailed below are pending from your client, Mr. Shrey Equipment Finance.
What about these two awards? There were two different awards.
There are two different contracts, two different awards.
He filed 234.
Yes.
He filed two.
There are two section 34
Yes, two
before us,
section, two
before
section.
me. Yes.
And my lord, it says this amount due has been given. The above mentioned fee and other charges totaling rupees so and so, and the hundred so and so in my favor. The bank details are given. To you. Your clients may be advised to deposit the amount within a week, so that necessary reply can be given. And my lord, kindly my lord see the details. I just wanted to indicate to your lordship the venue, secretarial assistance and conveyance charges, rupees 65,000 in respect of the award dated 17 September, and in respect of the 21st September, the venue, secretarial assistance and conveyance charges 65,000. So I take it, my lord, there must have been some venue had been some hall or some my lord, arbitration
Yes.
room has been bought by. I don't know how it was possible, because this was absolutely in the middle of the COVID period.
First period.
And well, not only that, at that time, your lordship will please remember, all these schools, colleges, courts, they were closed. And during that time, this happened. And these 3 dates, my lord, I shall just give your lordship the dates which transpired from this. My lord, one in January, I shall give your lordship the dates. Well, 3 dates are this: 15 January 2020, 8th May 2020, and 3rd July 2020, according to the records that I shall presently place before lordship. And all these 3 dates are in the height of COVID period.
15th of January was not the first date, was not.
The
but,
first date was
but the
perhaps-
next 2 years.
Yes. Now, my lord, then, my lord, when this letter was received by us, this is at page 347, 348. Then, my lord, ask 11th March at page 350, if your lordship kindly comes.
Yes.
A letter from my advocate again, addressed to my lord, the Srimati Bandana Ray. We are in receipt, reference to that letter, her letter. We are in receipt of your letter dated so and so, and had forwarded the same to our client for instruction. Upon receipt of instruction, we are writing this letter to you. Our client's Shrey Equipment has undergone corporate finance. I am not troubling your lordship, para 3. However, in terms of the approved resolution plan, new board of Shrey Equipment Limited is duly reconstituted on 26 February 2024. While the new management of our client is now in the process of looking into the records of our clients, request you to kindly provide the following: your Aadhaar card, your PAN card. These are for the purpose of payment of the dues. The dues which has a cross
Not for
cancel.
payment. The Aadhaar card and PAN card cannot be for payment.
Well, that kind
Maybe
of
to check the identity.
a cross cancel check. A copy of the minutes of the meeting wherein the fees of the arbitrator and other expenses have been determined. Copy of the letter appointing you as the arbitrator and requesting you to enter upon the reference in the matter. The aforesaid documents will enable our client to look into the matter further and take expeditious steps thereon. You will expedite the whole process. You are also requested to provide the necessary postal receipts for delivery of the awards in question upon our client. Then, my lord, this after the receipt of this letter, my lord, the letter was then, my lord, kindly come to page 352, the
Yes.
14th March. Another letter was written.
Yes.
To my advocate record. I write to bring to your attention the outstanding fees and charges totaling rupees 11,82,946, which remain unpaid despite my prior communication. On 5th March 2024, I provided my bank details On 5th March 2022, I provided my bank details for the purpose of remittance with copy furnished to your client, Mrs. Shrey Equipment Finance Limited. In the light of the aforesaid, I request you to expedite payment process with your client. It is imperative that this matter is resolved prior to any further correspondence regarding the arbitration award dated 17 September 2020 and 21st September 2020 between Shrey Equipment Finance Limited and Roadwings International Limited, wherein I have become functus officio after passing the award and returned all documents to the parties concerned, retaining the original award with me. So, my lord, it is an admitted position now that no copy of the award was served upon our client. So, my lord, this was the letter, my lord, which was written by the arbitrator at page 352. Now, my lord, I go into the facts of this case, my lord. I shall just very shortly, I shall indicate to your lordship the way I want to proceed in this matter. My lord, kindly take the award, because I don't have any paper at all, excepting this copy of the so-called award. Kindly, my lord, come to page 291.
Yes. Acha, এটা. So you started from the very beginning, sole arbitrator jointly appointed. There is nothing to show that
This is-
anything of that sort.
This is exactly, my lord, this
That
is
was
the
your point
my
on the
lord.
last occasion.
Your lordship kindly sees this. This is a very interesting award. It starts at page 291.
Hmm.
Appointed as a sole arbitrator by reference letter dated 29/12/19 in pursuance of arbitration cause.
So there's a contradiction in terms there also, because if it's jointly by claimant and respondent, with its reference letter,
Right.
it's singular. It's is singular.
Quite simple.
Anyway,
Then, my lord,
and
kindly.
next page is the date of the stamp.
Yes,
কোভিডের ঠিক আগের দিন ঘন্টা
You-
বাজলো 21 তারিখে
my lord, kindly see, this is 21st March 2020, if your lordship remembers, that day was announced. The 21st March 2020,
Yes. This was purchased on 20th of March.
20th of March. And my lord, it was purchased in the name of
No, purchased
The-
from
arbitrator. My lord, generally what?
1 second. This was purchased from Bosirhat Treasury,
Yes.
but in the name of the arbitrator who resides at Budo Shivtola. That is
Budo-
also another factor which should be looked into.
and long before the
Boshirat Treasury. Yes.
Bosirhat Treasury by a person who resides in the name of the person who resides in Budo Shivtola. Either of the parties are any office at Bosirhat.
No, I don't think so.
Doesn't appear from the names of the parties at
No,
least.
my
Yes. Very well. So that's
But
another point.
kindly see, my lord, para 2 at page 293. My lord, this entire award is, my lord, full of curious statements. I have to put it mildly. I have carefully considered and gone through the pleadings, paragraph 2 at page
Yes,
293,
yes.
and the pleadings, submissions, and arguments of the claimants, documents on record on behalf of the claimant, and case laws cited on behalf of the claimant and the respondent. I now proceed to make my award as indicated below, but before giving claim-wise award, it may be useful to give within a short compass the brief facts which led to the disputes between the parties and leading to the passing of the present award. Well, kindly note this thing. So far as the claimant is concerned, his pleadings were before her, submissions and arguments were before her, documents were before her, and the case law cited were before her. And so far as the respondent is concerned, respondent's only case law cited.
Yes.
Then, my lord, para 4.
But you are the purported claimant.
Yes, I am the purported claimant. Kindly come to para 4. The claim petition has been signed by the authorized person of the claimant, and he has been duly authorized to institute, sign, and verify statement of claim and to do all other acts, deeds, and things necessary for proper adjudication of the case by letter of authority of the claimant, which is annexed to the claim petition filed by the claimant. So, my lord, The claimant filed a claim petition, letter of authority, and annexed to the claim petition. These are recorded in para 4. Therefore, this should be also on record. 5. It has been averred that the respondents by an application applied for loan from the claimant for the purchase of rich stacker machine, and after considering the application, the claimant sanctioned to the respondent a sum of rupees 1,89,88,100 for the purpose of purchasing so and so. On specific terms and conditions and written agreement dated 15/4/2017, bearing agreement contract number 13035,853, hereinafter referred to as so and so, accordingly executed between the claimant and the respondent. The respondent was liable to perform the terms and conditions as a recorded. Then 6. The claimant company has placed on record, again, my lord, I made a note of it. The claimant company has placed on record a copy of the loan agreement dated 15/4/2017, executed between the parties. It is thus evident that the transaction between the parties is governed by the terms and conditions of the loan agreement number so and so dated 15/4. As per the terms of the agreement, the claimant states that in case the respondent failed to adhere to the fiscal discipline and commits default in the payment of EMIs, the claimant is entitled to terminate the loan agreement and can recover the loan amount with interest due from the respondent. And further, as per terms of the agreement, the respondent is liable and exclusively responsible to get the delivery of the said equipment to be hypothecated to the claimant. Accordingly, the claimant, through its lawyer, Sri Ayan Chakraborty, by letter dated 23rd May 2018, stated that in view of the failure on the part of the respondent to clear the dues of the said sum, in spite of repeated reminders by the claimant, as per terms and conditions of the said agreement, and therefore on behalf of the claim, his client hereby determines and terminates the agreement.
I have a note here, Mr. Mitru, from your previous argument that this letter led to a Section 9, which culminated in an order of acquiescence by them that the equipment could be appropriated.
Yes,
Something of that sort also happened.
yes, that is what has been recorded.
So this letter by Ayan Chakraborty is admitted.
Yes, that's
Up to that, yes.
Yes, at that stage. Then the claimant states that the respondent failed and or avoided to adhere to the terms of payment and in fact defaulted in paying the installments, is thus guilty of having committed defaults. It is contended that the respondent, while continuing to enjoy the use of the said equipment, started making defaults in payment of the installments of installments on various dates and failed to adhere to the repayment schedule. And the claimant company, as per the terms of the said conditions of the loan agreement, recalled the aforesaid loan facility by their letter dated 23rd May 2018, whereby the respondent was called upon to hand over the said asset forthwith and or to pay the outstanding dues. It is contended that as the respondent committed defaults in making payment in monthly installment, the claimant has become entitled to possess the vehicle in question and recover the entire outstanding dues from the respondent. Now, my lord, the natural question is this: when it said the claimant states and it is contended that the respondent, while contending, now, my lord, the question arises: who contended on behalf of the claimant? Somebody must have contended. Is it Mr. Ayan Chakraborty? I shall show to your lordship. He was specifically asked as to whether he did. He said that I don't know about this arbitration.
Claimant states maybe in the statement of claim.
Maybe it is
from
so.
the statement of claim itself. Maybe no counsel stated that's not submitted.
The claimant states in the first sentence, and it is contended that the respondent, while contending, maybe, my lord, it's possible.
Maybe that, yes, one of the
maybe
possible.
counsel লিখেছে পরে
It's up to this.
এখানে
298
এখানে Then, my lord, no, my lord is perfectly just right, my lord. The claimant states, and it is contended, maybe the claimant's contended. So, my lord, I am not going to put too much.
Maybe either way, yes.
I am not putting too much emphasis. Then, para 8, as per terms contained in the said agreement executed between the parties herein, In the event of default of breach of any of the terms and conditions schedule, the claimant is entitled to forfeit claim the balance outstanding in respect of for the so and so. Then, my lord, the claimant will I don't know whether
Yes, but
lordship's copy, I
para 10
think
respondents counsel.
the
So
claimant states that
maybe.
the respondent failed to pay the aforesaid dues, and then, my lord, the dispute has been
So we
the
can skip that.
arbitration clause has been set out.
Yes,
Then,
para
para 10.
10 counsel for the
Yes.
respondent, right?
The learned counsel for the respondent, however, elaborated the same by oral and written arguments, which is as under. So, my lord, we get here now that, my lord, this is a written argument was filed on behalf of the respondent by the learned counsel. We do not know who the learned counsel was. The respondent states that the claim is based on misrepresentation of facts. In the present issue, the claimant is asking for rupees 1 crore 89 lakhs, which is factually not correct. Bank statement and other collaborated documents, I think it should be corroborated documents, revealed and explains that although the claimant had sanctioned a loan of rupees 1 crore 89 lakhs to the respondent against the agreement number so and so, the loan amount which got disbursed under the said loan agreement and the amount that is actually received by the respondent from the claimant, as per the books of accounts, is only rupees 57 lakhs 25,095. Now, first of all, my question is, whose books of account? Secondly, my lord, who tendered them? Was there any oral evidence given? How did these books of account come into the picture, and where are they? And the figure, kindly see, my lord, 57 lakhs 25,951. To the last rupee, my lord, it has been mentioned. Therefore, the total liability of the respondent towards loan amount received under the agreement from claimant is only for the principal loan of 57 lakhs 25,000 along with interest and other charges, and not rupees 1 crore 89 lakhs.
Apparently, the respondent's books of account.
Must be so.
Respondent received by the respondent as per their book of account.
But here, my lord, as per their books of account, I suppose.
But if you read the inter sentence,
yes,
and the amount that is actually received by the respondents
from the claimant, as per their books of account, I should be my lord respondent. Maybe.
20 document আছে just
সেগুলো পরে আসছি proceed step by step, otherwise আমার তো কনফিউশন হয়েছে, জজ সাহেবেরও কনফিউশন হয়েছে। Then, my lord, para 12, that the claimant has claimed rupees 1 crore 89 lakhs towards principal amount plus interest and other charges, that the respondent has surrendered the hypothecated asset, that is reach tracker machine, to the claimant on 8/3/2020. The claimant has got the machine value through the approved value. The claimant has got the machine, I think, valued through their value, not value, valued through their approved valuer, who has valued the machine at rupees 75 lakhs as on 8/3/2020. The approved valuer has valued the machine, and the valuation report and the evidence of the valuer, they should be on record. I mean, that should be my.
Might be in connection with the section 9 proceeding.
No, section 9 is 18, 2018.
That the respondent states that they have paid rupees 38 lakhs to the claimant as per the details below. The details have been given.
Show the details up to 2018.
And, my lord, it is kindly see that the details are starting from 2017 up to 2018, 26th April. The surrendered machine is valued at rupees 75 lakhs. And adding the payments made by the respondent to the claimant, totaling rupees 1 crore 13 lakhs, as against the loan disbursed amount to the respondent amounting to rupees 57 lakhs and odd, which is much in excess of the value of the loan amount received and the interest and other charges payable under the loan agreement. Thereby, the claimant has paid rupees 55 lakhs 74,000 in excess towards interest and principal charges. That therefore, the respondent states that they have paid back the full amount of loan against contract number so and so dated 15/4. Then, my lord, the claimant company issued a letter to me
Not
hereby
joint.
nominating me as the sole arbitrator to adjudicate upon and decide the dispute of claim made by the claimant against the respondent, and asked my concurrence to act as the sole arbitrator in terms of the loan agreement. The respondent duly consented to my appointment of a sole arbitrator, accepted my appointment, and concurred to act as a sole arbitrator for adjudication of the dispute having arisen between the parties. Then confirmation was sent by both parties directing them to appear before me. My lord, your lordship will please to see. First is here the claimant company has issued, that statement is claimant company has issued a letter appointing her as a sole arbitrator. Therefore, we have appointed her. First of all, I would like to know where is this letter? And then, my lord, who has signed this letter and when? Then, my lord, this second is this: upon my appointment, the respondent has concurred in her appointment as sole arbitrator. And the third letter is she has agreed to act as the sole arbitrator. So 3 documents should be there.
No, no, that was fourth document. Confirmation was sent.
Accepted my appointment. So there are 3 letters. Why I'm saying issued, claimant company issued a letter first. Then the
Yes, claimant's letter, consent letter, acceptance of appointment, and confirmation sent.
confirmation. Very well. That in view of the above arbitration.
In this case, the respondents have also produced only the copy of the award. No pleadings, nothing.
Nothing.
Respondent has not produced any.
No, they produced that copy of the award, purported award in connection with the IBC
In
proceeding.
the IBC proceeding.
Apart from that award, nothing has been.
Nothing has come from them. That in view of the above arbitration agreement between the parties as stated in the prayer clause, the said claim petition, that now I consider the claims preferred by them. Recovery of 1,89 lakhs. Well, that thing has been reiterated. It is evident that one can see the claimant company has placed on record a copy of the loan agreement dated so and so. So we are supposed to have placed this, executed between the parties. It is thus evident that the transaction between the parties is governed by the terms and conditions of the loan agreement. Number so and so, dated so and so. As per the terms of the agreement, in case the respondent failed to adhere to the fiscal discipline and commit default in payment of EMI, the claimant is entitled to terminate.
She proceeds entirely on the basis of the pleadings. I mean,
Yes.
purported pleadings. Even the next page, the payments, she reiterates what she did in the previous paragraphs.
Before the paragraph 3,
Yes.
at page 298,
Yes.
kindly see the claimant company has also placed on record a copy of the statement of account
Yes.
of the loan account, which shows that the details of the amount financed, rate of interest, EMI amount,
Yes.
tenure of the loan, payment made by the respondent, and also the outstanding principal amount and the interest and other charges payable by the claimant company. I would think that this is a very beautiful arbitration in which, my lord, everything, my lord, came on record. On the basis of it, the learned arbitrator. The only thing is, I asked the claimant, if the claimant had placed this on record, they should be on record. If it is not, if the arbitrator is not willing to produce it, why should my respondent not produce it before the court?
That is what I asked, that whether they have produced any pleadings also.
My lord,
একটা শুধু দিয়েছে evaluation ওরা একটা 75 lakhs এর দিয়েছে
yes, that I have shown to my lord, that there is only valuation report was rupees 75 lakhs. My lord.
Yes,
Where it came
valuation
from,
report of the machine.
yes.
But regarding this page 299, this chart, that no document is discussed in the award
No,
in support of that.
in support of that. This is
Only
just a
their
short
accounts.
statement.
it is up to 2018
Yeah, I'm sure they can.
Yes, 2017-18 years.
2000.
Mr. Mitra, I have a division bench from 1. So I'm sorry, I have to rise.
এখন কবে হবে এটা last
Next Thursday and Friday. No, sorry, next Friday.
Next Friday.
Next Friday. Hard in court for further hearing on.
I shall just indicate to your lordship the factual part of it, make my submissions and my.
Yes, you have for further hearing on September 19, 2025.
Lord, I beg to appear on behalf of the petitioner. Now, Lord,
I am appearing for the respondent number 1.
Lord, may I take just 1 minute time of this honorable bench? Now, Lord, it's a suit for partition. Suit was decreed in preliminary form. There was partition commissioner's report accepted, final decree. Challenging that, we came in first appeal. Now, my lord, we filed an application for repairing. That has been allowed by your lordship, that is annexure P3, with a rider that if in case of repairing of some portion, you do require the permission of the municipality, you take that permission and do that thing. None of the parties challenge that order either before this honorable court or anywhere else. Now we submitted a representation before the municipality. Municipality asked us to give an undertaking in a notarized form. We gave that undertaking. Pursuant to that, a 4-line order allowing us to repair has been given. Now, my learned friend's client challenges that order in a proceeding under section 144 CRPC, which is corresponding to 163, if I am not wrong, of BNS. Now, the contempt application has been taken out against the very learned
No,
executive.
the 144 CRPC could
Yes.
not be a challenge to something.
No, what happened?
They
He-
independently took out an application alleging that you are disturbing the peace or something
I am
by virtue of that repair work.
repairing work.
So that is a resistance to the order of the court. That is what you are
That
saying.
is their contention. Now, the learned executive magistrate decided to sit in appeal over the order passed by your lordship. And
This is a contempt against the magistrate.
yes, not against them.
Achha.
Kindly, my lord, take up the
This for the appearing. Did you direct it to serve
No,
copy?
no,
This for the
no,
first time.
I've just my first time.
Did
It
the
has
magistrate do?
Lord, kindly, that is kindly come to my lord's order at first at annexure P3.
For the others, Bhubaneswar Shah and others.
Well, that
Oh no,
my
that is the original question.
That,
Right.
that is
Very
now what my lord kindly will not kindly come to the order passed by the learned magistrate. I have given the
Yes.
type copy in the my lord in the body of the petition also. I have typed it. My lord, kindly my lord, come to page 15, paragraph 22. Page 15, paragraph 22. Has your lordship
Of the contempt application.
of the contempt application? Now, what have quoted. In the meantime, Rampurhat PS is directed to inquire and report in, that is not legible, of apprehension of breach of peace over the dispute and see that peace is maintained by both the parties. The EO, executive officer, that is, my lord, Rampurhat municipality is directed not to issue any permission from his office to the OP on the basis of constitutional order of Honorable Calcutta High Court, Vaidi FAT number Ato, because the matter is sub judice for title execution case being number 1 of 2023 in the Court of Learned Civil Judge Senior Division First Court at Rampurhat. And the petitioner has also obtained the final degree from the Rampurhat Civil Court, Vaidi title Suna. The EO is also directed that before issuing any permission to the OP, if applied, the hearing should be taken from all the interested parties to make the matter transparent.
Have you got a copy of that order?
Yes.
Where
The
is that?
handwritten copy, my lord, kindly.
Yes,
submit.
yes. Where is that?
It is at annexure P8 at page, my lord, 56.
Not constitutional, conditional order.
Maybe conditional. No, question is, one of the senior most division benches of this honorable court has given us
Even
permission.
the junior most division bench.
Also, but
That was probably the junior most division bench. Then, yes.
I leave.
Till today, we are the junior. As a division bench, I am the junior most.
But kindly see.
No, but on basis of condition. Permission of the officer. Constitutional যেটা লিখেছে ওটা conditional. Condition. Execution के subjudice হচ্ছে ওটা।
Where is our order?
Annexure P3, my lord.
P3 তে দিয়েছি।
Number, sir?
Page number, I'm giving your lordship. Yes. P3 is at page 46.
48 এ হচ্ছে ordering portion.
My lord, kindly start from
Nine.
page 48, paragraph 8.
আচ্ছা হ্যাঁ এইট is a copy of the 144 or whatever new section that application is annexed here. Copy
Yes,
of
my
that
lord, kindly come to page 54.
Have they disclosed about the?
Yes. Kindly come to 8th line. উচ্চ আদালতে ক্যান 2 অফ 2024 মোকদ্দমা দায়ের করে।
on the basis of the conditional order passed by the Calcutta High Court. Order is বলছে।
They have mentioned ক্যান 2 অফ 2024 মোকদ্দমা দায়ের করে উক্ত মোকদ্দমায় উক্ত আদালত রামপুরহাট মিউনিসিপালিটিকে বিবেচনা করিবার জন্য পাঠাইয়াছেন। কিন্তু মিউনিসিপালিটি উভয় পক্ষকে না ডাকিয়া কোনরূপ স্পট এনকোয়ারি এখনো পর্যন্ত করে নাই বা উক্ত কার্য কোনো অনুমতি তথাপি হঠাৎ করে লো বলে জোর করিয়া উক্ত জায়গায় নতুন কনস্ট্রাকশন করিতেছে।
Please, Vishwas, why did you go to the magistrate? You should have come before this court if this was your complaint. Why are you not in contempt also?
Yes, my lord. First of all, I'm praying for apology for this kind of
You're appearing for the?
apology. I am praying for apology for.
You are appearing for whom? The private
Uh,
parties?
Respondent number 1.
Yes, because you should have approached us,
Yes,
saying
my
that
lord,
they are doing it without in violation of.
That is true, my lord. Basically, it has it should not done by my client, my lord.
Yes.
But actually, my lord, kindly see the order, my lord. What they have prayed for, they have prayed for repair, not for reconstruction. That is initial.
But that is our domain.
That is
Magistrate,
true.
can the magistrate? Can you ask
Well,
for the
kindly
magistrate?
see,
How could you approach the
order-
magistrate with this complaint even?
Yes, but kindly see your lordship's order. Kindly paragraph 8, my lord.
You have never complained before us. How do you look into this?
Yes.
You have gone to the magistrate by complaining that they have not complied with the order of the High Court.
That should not do.
Yes. We have permitted reconstruction. Subject to obtaining sanction, they have obtained sanction. If you have any difficulty with the sanction, you could have come before us.
That is true, my lord.
This is clear violation on your part also. Why shouldn't your client will direct a,
Totally change the nature and character.
will direct you to be implemented also, and you also file your opposition.
My lord, only your lordship's order only reconstruction of roof, but instead of that, they have totally changed the ground floor, my lord. They have already broken the floor. And
You cannot approach the magistrate, which is not even the trial court.
yes, that is.
Magistrate is a different forum. You approach the executive magistrate for complaining violation of an order of the High Court.
That mistake has done by my.
No, we will, Mr. Mukhopadhyay, please implicate them also as a party.
Yes.
A prima facie case of contempt has been made out. Full stop. Next para. This court, comma, vide order dated December 16, 2024, passed in Can 2 of 2024, comma, an application for repair filed in connection with FAT 70 of 2023, comma, had inter alia permitted the petitioner to undertake repair as sought in paragraph number 4 within bracket small a of the said repair application, comma, that is, comma, the reconstruction of the ground floor roof, comma, we had permitted the petitioners to carry out the necessary repair works as indicated in point numbers small b within bracket, comma, small c within bracket, comma, small d within bracket, comma, small e within bracket, and small f within bracket of paragraph number 4 of the repair application, full stop. Insofar as point number small a within bracket, the appellants were permitted to undertake the said repair works subject to sanction being obtained from the concerned municipality if so required in law. Full stop. Next para. Learned counsel for the petitioners submits that in pursuance of the said order, comma, the petitioners obtained sanction from the concerned municipality and undertook repair work. Full stop. At this juncture, comma, an application was filed under section 163 of the BNSS by the respondent in the appeal, comma, thereby alleging that the petitioners, comma, in order to harass the respondent, comma, has filed Can 2 of 2024 before this court, comma, in which application, in connection with which application, comma, this court had directed the matter, sent the matter to the Rampurhat municipality for consideration. Full stop. It was further alleged in such application, comma, as evident from a copy thereof annexed to the present contempt petition, comma, that the respondent in the appeal further stated that the municipality, comma, without without giving opportunity to both sides or without any spot inquiry, comma, that the municipality did not call either party or hold any spot inquiry and has not granted any permission to undertake such repair work. Full stop. In such context, comma, the alleged contemptor, comma, the concerned executive magistrate, comma, passed an order on July 30, 2025 to the effect that the executive officer of the Rampurhat municipality is directed not to issue any permission from their office to the opposite party on the basis of, within double inverted, on the basis এর আগে থেকে double inverted হবে, on the basis of the conditional order of the Honorable Kolkata High Court, vide page 15.
Page 15, yes, my lord.
Yes.
Right. By the FAT number 70 of 2023.
Very well. By the FAT number 70 of 2023, because the matter is sub judice for title execution case number 1 of 2023 in the Court of Learned Civil Judge, bracket Senior Division, comma, First Court at Rampurhat, double inverted close, dot, dot, dot. Next para. It is evident from the tenor of the application that the statements made therein by the respondents in the appeal misrepresented the actual content of the order passed by this court, inasmuch as this court had not sent the matter to the Rampurhat municipality for a consideration, but had granted liberty to the appellant stroke petitioners to carry out repair work, comma, obtaining necessary sanction, comma, if required, comma, from the said municipality. Full stop. Secondly, comma, it has also been insinuated, comma, after the order of this court is passed, comma, that the said application was filed for harassing the respondent in the appeal. Full stop. Thus, comma, such act on the part of the respondent in the appeal is prima facie contumacious. Full stop. Respondent number 1 hobe jekhane respondent boleche contumacious. Full stop. The order of the executive magistrate, comma, prima facie, comma, is contemptuous of a higher order, comma, since the alleged contemptor, comma, being an executive magistrate, comma, in a proceeding unconnected with the first appeal pending before this court, restrained the executive officer of the Rampurhat municipality, comma, in the teeth of the permission granted by this court, comma, from issuing any permission, double inverted, on the basis of the conditional order, double inverted close, court of this court, comma, thereby virtually restraining the said municipality from implementing the order of this court. Full stop. Such sort of injunction by the executive magistrate is unheard of in legal parlance and smacks of deliberate and willful violation of the order of this court. Full stop. In view of the above prima facie observations, comma, the petitioners are directed to implead the respondent number 1 in
1
the
and 2, my lord.
1 and 2 wrote.
Yes.
The application was by both.
Both 1 and 2 plaintiffs.
No.
Bhubaneswar
Only one.
Saha, my lord, page
Only one.
54.
Respondent number 1 in FAT 70 of 2023, namely Bhubaneswar Saha, uh, as an alleged contemner in the contempt application, full stop. The appellant, the petitioner shall serve copies of the contempt application on the alleged contemners, comma, including the added contemner, comma, namely Nazim Ali Mufti, MUFTY, and Bhuvaneshwar Saha, indicating that the application shall next be listed for hearing on কবে আপনার সুবিধা মতো নভেম্বরে পুজোর পরে তাহলে আমি এখন আপনি ফ্রি থাকবেন এখন সিঙ্গলি দুদিনে দিয়েছি তাহলে নভেম্বর 7th রাখবো না 14th 14th November November 14 2025 full stop. Next para, affidavits in opposition to the contempt application, comma, if any, comma, shall be filed by the alleged contemners by September 26 2025, full stop. Reply, if any, shall be filed by November 7 2025. The matter will appear on 14th, those timelines.
দিয়ে দিয়েছে একটু কারেকশন হবে না না কারেকশন হবে নাম ব্যাড
আরেকটা item. That's a different matter.
This is my contempt
My lord,
application.
I am appearing for the respondents, my lord. I have not been served yet.
Lord,
You're not supposed to be served unless you are satisfied. Yes.
but there was an order dated 12th.
Oh, there was a direction for service? No.
No direction. I'm appearing for the.
What is
first
the
time.
nature of contempt? First,
The nature of the contempt was that one kindly comes to page number 22. My lord, the order first. Para 6.
Third party interest.
Third party interest and changing the
What-
nature and character of the
what
suit
have
property.
they done according to
My
you?
lord, the suit property, my lord, entirely demolished.
It is alleged in the contempt application that in stark contravention of the order dated December 12, 2024, passed in FMAT 437 of 2024, comma, with Can 2 of 2024, comma, whereby an injunction was granted in respect of the suit property, comma, the entire suit property has been demolished by the alleged contemners. Alleged contemners, yes. Full stop. Next para. Since, what is your full name, please, ma'am?
My lord, Ms. Sriparna Ghosh.
Ms. Sriparna Ghosh, comma, learned advocate, appears and submits that she has instruction to appear on behalf of the alleged contemners. Full stop. Accordingly, a copy of the contempt application be served on Ms. Ghosh during the course of the day.
Only my lord, respondent number 1. Since I don't have the
Contempt
copy,
number
copy,
one.
my lord.
যেখানে বললাম for the alleged container number 1, full stop. Accordingly, a copy of the contempt application be served on Ms. Ghosh, which shall be treated to be good service on the alleged container number 1, full stop. Insofar as the alleged container numbers 2 to 4, comma, copies of the contempt application shall be served directly upon them by the petitioners at the earliest, and an affidavit of service in that regard shall be filed on the returnable date. Full stop. Affidavits in opposition shall be filed individually by each of the alleged contemners by September 26, 2025. Full stop. Reply, if any, shall be filed by November 7, 2025. The application shall next be listed on November 14, 2025. এই দুটোতেই না, দুটো অর্ডারই না at 1 PM করে দেবেন। 1 PM এ রাখি?
Yes, madam.
Thank you.
May I permit to mention a contempt application for inclusion?
Yes. Single bench. Call. Yes, Mr. Nandi.
Yes, Lordship.
Good to see you again. Yes. What now?
I bowed out because I couldn't appeared on 3rd and 11th.
Yes.
Because I was being told that it is only on Friday.
Yes, we
why-
take it up only. Yes.
That's a.
No difficulty. Thursday was all on a sudden we decided to because certain other matters. Anyway,
Your
what is the
Lordship, we
matter? Yes.
Ordered for on 22nd March.
Yes.
That which has been served, the envelope which has marked on 2nd April it has been sent. On 3rd April it has returned, and that envelope is intact. So I need a direction that to whom I'll pay the.
Oh, you want a clarification for that?
Your Lordship.
Oh, you sent the costs to the contemner?
Yes, Your Lordship. This is this envelope is not yet been opened. This is the not yet been opened.
It contains a check?
Yeah, Your Lordship.
Left. Were they represented by advocates initially?
No, Your Lordship.
No, in the contempt they were not, but no. But in the main matter, in the CO number, in the civil division, they were represented by counsel.
Yeah, Lordship.
Do you know the name of the counsel? I'll just check up whether it's there.
Civil division, they have not appeared, Your Lordship.
Oh.
They have not appeared.
Then you have done your duty. What else can you do?
Your
You
Lordship.
keep this with you.
Your Lordship.
We'll record that. I'll record that you have sent, but it came back with the endorsement left. So, but we'll have to keep something on record then.
Should I hand over the check?
Check we don't want to keep on record.
No, no.
because
Achha.
It's expired now.
Naturally, 3 months is the
3 months is over.
over.
Then we'll keep that on record. The entire thing, please hand over. I'll keep on record. I'll pass an order.
Your Lordship.
The
This check, this envelope, along with envelope.
yes. Very well. You are the
Petitioner, Your Lordship.
no, you are petitioner Moni Monjusha Nandi.
On behalf of that, I
Your
with
wife?
the power, yeah, my wife.
Mr. Radhanath Nundi, appearing in person in the capacity of the constituted attorney and representative, in person of the petitioner Mrs. Moni Monjusha Nundi, submits that in compliance of the order dated March 22, 2024, passed in CPAN 8 of 2023, he had tendered the costs of rupees 10,000 by way of a check to the alleged contemner. However, the envelope containing the said check has returned with the endorsement double inverted left. Next para, Mr. Nundi files in court the receipt in that regard as well as the envelope containing the check. Let such receipt, postal receipt and envelope containing the check be kept on record. Next para, since it is evident that the petitioner complied with the direction to pay costs as passed by this court, but the same could not be served in view of the alleged contemner being unavailable at his address, it is deemed that the petitioner in the contempt application has sufficiently complied with the order dated March 22, 2024. Accordingly, no further order need be passed in that regard.
Much
Thank you,
obliged and
Thank
grateful. Your Lordship.
এটা স্টেপল করে রেখে দেবেন যাতে চেক ওয়ালা এনভেলপটা পুরোটা স্টেপল করে রেখে দেবেন, খুলবেন না, ওটা ওরকমই থাকবে। থ্যাংক ইউ।
Much obliged.
Yes. ফাইল নট হিয়ার নাকি? তাহলে কি করে হবে? আজকে ফাইল নটে টু করেন না। This is the second occasion when none appears for the parties at the time of call, full stop. As a last chance to the appellants to appear and argue the appeal, comma, the same is adjourned till September 18, 2025, when it will be listed under the same heading. Next বৃহস্পতিবার। ওই দিনও কিন্তু থাকবে 2টো থেকে। এটা কি একই জিনিস? না, এটা আগের দিন কি অর্ডার হয়েছিল? এটা প্রথমবার এসেছে? তো আগের দিন এসেছিল। The office report dated September 10, 2025 is not satisfactory, comma, in view of the same not disclosing the particulars of the postal requisites filed for the purpose of service of notice and stroke or the details as to when such notice was issued, as well as to what steps have been taken for intimation by the office for the purpose of obtaining the trial court records. Full stop. Accordingly, the office is directed to file a further revised report containing detailed particulars in the above regard. Full stop. The matter shall next be listed on November 7, 2025. Although from the office report dated September 11, 2025, it transpires that the trial court records have been received on July 12, 1978, comma, till date the trial court records have not yet been examined. Full stop. It is rather surprising that it is so. Full stop. Be that as it may, comma, the office is directed to immediately examine the records and furnished a revised report as to whether the appeal is otherwise ready as regards the hearing. Full stop. The appellant shall file the requisite number of informal paper books without comparing with the records within September 12, 2025. Full stop. The matter shall be listed next on September 18, 2025.
That batch of crop insurance matters.
Yes.
That crop insurance matters. Now,
Crop
we have
insurance.
taken out an application for recalling. Readings have been exchanged. And my lord, I don't,
One of the banks.
well, the read petitioner, I believe, is
16 who someone is appearing for the bank.
what I was humbly requesting, my lord,
Yes,
but instead of treating this matter, as I pointed out from day one, as an adversarial one, if somehow, my lord, if your lordship permits us, subject to your lordship's permission, if somehow, my lord, we can get the state government on board in this matter, I think, my lord, some fruitful purpose can be served, subject to lordship's kind consideration.
No, absolutely.
My lord,
In a contempt, how far we can do
my
that?
lord, recalling is there.
Oh, recalling.
In the recalling, my lord, if your lordship permits us, my lord, I believe, my lord, if we can work out something for them, if the state can take the responsibility.
Fair suggestion. What should be the state through whatever you ascertain, you know better.
We will implement the relevant
It has to be the state of West Bengal
appropriate department through
will direct you to
serve copies of all the
implement them in the recall application and
yes,
serve
my lord.
copies.
My lord, by my lord, if your lordship allows us to implement them by in the cost title itself, my lord, if we can add them.
Yes, that is what we.
Yes.
Because,
maybe
my lord, I
fine.
don't want, my lord, they should be left high and
No,
dry.
no, the bona fides are not in doubt.
My hands are seriously tired. My lord, I
Hmm.
would have, otherwise I would have definitely taken a different stand.
You are appearing for the insurance company.
Yes, my lord, insurance.
My lord, the recalling
I am for the
applicant's
petitioner.
insurance company's affidavit in reply, my lord. against
Oppositions have been filed.
Yes.
Yes, everything
My
has.
lord, the reply to the writ petitioner and reply to the bank. My lord. Opposition was filed by the bank as well as, my lord, in one of the matters, the string has come out. my
এটাই,
lord,
or-
All right.
2021 applications.
The affidavits in reply.
Agriculture department, sorry, agriculture department of agriculture.
Agriculture. The affidavits in reply filed on behalf of the insurance company in all the matters, respectively to the affidavits in opposition filed by the writ petitioners, as well as the banks, be kept on record. For sub next para, learned senior counsel appearing on behalf of the insurance company, fairly, suggests that in order to give appropriate relief to the petitioners, who are cultivators, with regard to the crop insurance scheme concerned, the appropriate department, I'm keeping it fluid,
Yes,
appropriate
ma'am.
department of the state of West Bengal may be directed to be impleted. Full stop, next para. Accordingly, the insurance company is granted leave to implement the appropriate department of the state as parties to the recall application and serve copies of the recall application on the said added respondent. Full stop, an affidavit in service in that regard shall be filed on the returnable date. Full stop. Let the matter be listed. When should he list it?
I think it should be after vacation.
Definitely after vacation, but first week, first Friday or
না,
second?
করতে হবে না, just নামটাই দিয়ে দিতে হবে।
Yes.
Yes.
I'll put that in also.
Yes, ma'am.
আরেকটা shall next be listed on টা ডেটটা blank রেখে তারপর লিখেন যে
Just হাতে
the learned advocate on record for the insurance company in all the matters is further granted leave to carry out the necessary corrections for such implement in the cause titles of the recall applications. A returnable date which would be a suitable date to all of you.
Well, your lordship's convenience, ma'am, obviously.
Then first Friday after reopening we are keeping it.
Yes,
7th we are reopening on 3rd. No, before that in October end.
Well, second Friday.
That would be the second Friday because we are reopening on 24th.
Well,
That will be the third Friday.
Friday is no Friday for us.
No, but the next one is a long week.
Well, next one is a long week.
31st.
Very well, ma'am.
So we are keeping it the week after that. Let us keep it if you have any difficulty.
We will come back.
Returnable date হচ্ছে November 7, 2025.
Well, corrections will be made during the course of the
Yes, we have given you leave, you can correct right now. And you have to serve copies also before the vacation, otherwise.
We will definitely.
And Mr. Mujumdar, use your good office to tell whoever to appear when the matter is.
That's a
Now it's a difficult
that's a
thing
tough
under
call.
changed
That's a tough-
circumstances.
Changed circumstances. Well, can we serve upon the learned advocate general? I think that will be
No, they'll later on disown.
then
Serve on the department.
Department is or through the learned government pleader, my lord. Through the learned government pleader, that can be done, my lord. That's a
যেখানে বললাম and shall serve copies on the added respondents. Serve copies on the added respondents যেখানে বলেছে।
জিপি সার্ভিস করে দাও। জিপি
একটু আগে
জিপি সার্ভিস করে দেবে, ব্যাস হয়ে গেল, আমার কি আছে। না, আমাদের করতে হবে।
granted leave to
আপনাদের
carry
কিছু করতে হবে।
ওখানেই বলেছি।
দেখছি যদি কিছু স্টেট কেস কিছু করা
হ্যাঁ তারপরে হয়ে গেল।
হ্যাঁ, এগ্রিকালচার ডিপার্টমেন্ট অল্প দিয়ে
Respondents command directly and or to the learned government pleader. Give your names. All the matters same order.
Grateful, man.
Government pleader, Mr. Anirban Rai is there. No, who is there?
No, man.
No, Mr. Amitabh Broto.
Mr. Amitabh Broto Roy.
Oh, yes. I remember the WhatsApps. Yes.
It is a ray, but not that a ray. Well, we wish your lordship a belated happy birthday.
Thank you. Thank you.
Get food, your lordship.
তো 3:30-এর আগেই শেষ হয়ে যাবে। একটা পেয়েছি ডিসমিস করার মতো। It is seen from the records that this is the third consecutive occasion when none appears to move the contempt application. Full stop. On August 8, 2025, comma, when the matter was called on for hearing, comma, none appeared to move the contempt application, comma, which was repeated on September 3, 2025. Full stop. Accordingly, CPAN 763 of 2025 is dismissed. If you're appearing, then on contest.
Yes, yes, yes. I'm the petitioner.
Then on contest.
6. But I had.
This is the third occasion you were not appearing. Kete dao ota, kete dao. Yes, what is the matter?
I'm present now. Actually, second occasion, my lord, I am in Jalpaiguri Circuit Bench. There also I.
Yes, actually, that's the court's problem. You're right.
There was.
Court should have been aware that you were in Jalpaiguri and should have taken care of.
Came online.
The first occasion you were where?
First
In
occasion-
Timbuktu or
First occasion, what happened, my lord? I do not know the matter is listed.
marriage? Your marriage?
Matter is listed, do not know. I'm sorry, my lord.
Now you know what is the matter about.
My lord, in 2023, my lord,
Yes.
the petitioner have filed a writ petition regarding the shifting of the slaughterhouse.
Shifting of his
Slaughterhouse, my lord. you are very
slaughterhouse.
well
Yes.
aware.
Then
Yes.
what happened?
And due to regarding slaughterhouse, my lord, because there is no lack of proper drainage system, in which, my lord, you have passed an order also.
Where is that order? Which page of the contempt?
Next to the order, my
Which page? Which page?
page, my lord, annexure A, my lord, and a P1, my lord. I don't have that page with me.
Panchayat Pradhan.
Yes, my lord. You directed the
Panchayat Pradhan was to deal with the same.
No, my lord. I personally.
Was to deal with the same as per the order.
Yes,
What?
yes.
No, my lord. What happened then?
After the passing of order, my lord, I personally sent notice along with the certified copy of the order. Till date, no step have been taken. After 2 or 3 days, after the villagers of the locality went to the Panchayat office along with the copy of the order, she not only humiliated them, but also insulted them. They don't bother the order. They don't. On the same day, my lord.
Insulted the court.
Yes.
What did she say about the court?
They don't bother this order.
Oh, that is nothing. That we are accustomed to. Even advocates regularly say.
My lord, and this.
Mr. Sinara regularly says that when he goes outside the courtroom.
No, my lord. And they on the same day, my lord, they went to the also.
No, remain in the courtroom. You can say that in the courtroom also.
They,
Very well. The learned counsel for the petitioner alleges that in violation of the order dated May 1, 2024, passed in WPA 29005 of 2023, comma, whereby the Panchayat Pradhan was directed to deal with the grievance of the petitioner in accordance with law, comma, the Panchayat Pradhan, comma, that is the alleged contemner, comma, when so approached by the petitioner as well as other villagers with a copy of the order, comma, did not care to comply with the same. Full thus, comma, prima facie case of deliberate violation of the order of this court has been made out. Full accordingly, the petitioners shall serve petitioners shall serve a copy of the contempt application on the alleged contemner, indicating that the application shall next be listed on November 14, 2025. Full stop. Affidavit in opposition, if any, shall be filed by the alleged contemner within November 7, 2025. Full stop. Reply, if any, shall be filed by the next returnable date.
Much obliged.
November 14, serve immediately so that they can file their opposition.
Okay, ma'am. I will.
Not okay, yes.
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 My lord, in item 27, I'm praying not today only.
You are for the petitioner. This is the first time in your life you are asking for a not today. Why?
No,
Refused. You are for the petitioner, move the matter.
My lord, actually, this is the instruction of the client to.
Not to proceed with the contempt.
Not to proceed, not.
I will not record that. Very well. So when should you keep it next week?
Next Friday.
No, now we are taking up on Thursdays and Fridays. So we'll keep it next Thursday.
Next Thursday.
Right. On the prayer of the petitioner, let the matter stand adjourned till September 18, 2025, which is next Thursday.
Number 20, Lordship, I am appealing for the petitioner.
Yes.
Lordship, the case of the petitioner is Lordship.
So, Bhattacharya, you are for the respondent.
I am for the respondent. Lordship, the case of the petitioner is Lordship, the petitioner participated in for the post of assistant teacher.
Why was this assigned to this court?
Lordship, it was assigned because Lordship, I asked for information. I was praying for information, RTI information before the honorable court.
No, why is it assigned to this court? I mean,
But it-
released by some other court.
It was released by the coordinator bench, Lordship.
You wanted an RTI information.
Lordship, there was a direction by your Lordship to file affidavit of opposition and reply indicating the RTI information which I have asked for, Lordship. They have affidavit has been exchanged, Lordship.
You have filed your affidavit of opposition?
Yes, we have filed the reply, Lordship.
Oh, yes. So, what did they say in their opposition?
Lordship, Lordship, the case of the petitioner is that Lordship, they have participated for the post of assistant teacher before.
No, your grievance was initially that they were not giving any reply.
Lordship, yes, Lordship.
Now they have given a reply.
They have given the information under right to information after.
Given the information also.
Yes, yes. They have
So then this has become infructuous.
No, Lordship, prayer B, Lordship. Kindly comes to prayer B.
Let us see your queries first and the RTI Act.
Lordship.
Was this query meant to initiate another series of education litigations?
A 2006 selection process.
Now,
Petitioner came before this court 2022. Selection process conducted, appointment was given by the council.
he wants to start a new round of these interesting litigations.
Lordship,
Matter is infectious because
No,
petitioner.
let us hear.
Yes, yes.
You take your seat, Mr. Bhattacharya will hear. Yes.
Lordship, the petitioner is praying before Lordship the appointment.
Where is your question? Where do I get it? Which page?
Lordship,
you don't have a note of your annexures. Where is your question?
Lordship,
Query?
page 17, Lordship.
Page?
17.
17.
Petition.
My lord, I am hand over the list of dates.
If you give a copy to him only then. You don't have any extra copy?
Yes, yes, yes.
Give a copy to him.
Lordship,
ওবিসি ক্যান্ডিডেট কতজন শিক্ষক নিয়োগ হয়েছে তাদের প্রত্যেকের নাম একাডেমিক স্কোর ওবিসি ক্যাটাগরিতে কতজন শিক্ষক নিয়োগ ইউ অলসো বিলং টু দ্য ওবিসি ক্যাটাগরি
Lordship. Very good. Lordship, then kindly comes to page.
Next page, yes.
Page 18, Lordship.
Yes.
Page 18, Lordship, they have, I have asked for my marks, Lordship, because marks was not disclosed in the year 2018.
Third query. আমার
Yes,
তৃতীয় প্রশ্নটা
Lordship,
তৃতীয় প্রশ্ন was not there.
page 18, Lordship.
2 তারিখে No, the first query is dated 26th of August 2013. At page 18, you say that on 2nd September 2011, acha.
Page 18, they have replied.
So
only-
this is another. This is the third question.
Lordship.
Very well. Then what are the answers?
Lordship, wherefrom I have got that I have got 38.32 marks and cutoff marks was 41.08. Kindly comes to column 5 and 6, Lordship, point 5.
Where is the answer?
Lordship,
Their
this is the
opposition,
answer.
they have annexed the answers.
Lordship, they are annexed the answers. I have prayed for the unfilled vacancy, how much vacancy was left.
They've given
They
that
have-
question.
Lordship.
So what has not been done now?
Lordship, I am praying for an appointment under the unfilled vacancy.
That's a different cause of action. You have to then apply, make a fresh writ petition for that. This is only regarding your grievance that they were not giving answer to your RTI query.
Lordship.
If they have given the answers, this writ petition has spent its force. This has become infructuous because they gave the answers after you filed your writ petition.
Lordship.
Even then, now it has been rendered infructuous. So we'll.
Lordship, prayer B, Lordship, kindly considers my prayer B. May I read, Lordship?
Prayer B,
Read
yes.
offer in the nature of mandamus do issue commending the respondents, their agents, servants, subordinates, and each one of them to to consider the candidature of the petitioner if there is any vacant vacancy of the OBC candidates in the 2006 selection process, or if there is any non-joining vacancy in the 2009 selection process. There is vacancy, Lordship, and kindly comes to my reply, Lordship, as well satisfied.
No, 2006 selection process, you participated there,
I participated, Lordship. I participated.
but you did not qualify or what?
I participated. My name was not impaneled, Lordship.
You did not get the qualifying marks.
Lordship, my marks, I came to know my marks on 2000. I came to know my marks.
Yes, whenever you came to know, are those the qualifying marks? Or it's below that?
Below, Lordship, below cutoff marks, Lordship. But
then,
Lordship, kindly comes to my reply, Lordship. Affidavit
this is for what post? This is for
assistant teacher, Lordship.
assistant teacher. We cannot compromise the standard of the assistant teachers.
Lordship,
If you don't get the qualifying marks, bad luck to you. The cutoff marks you have to get.
Kindly comes to my affidavit reply as satisfied, Lordship.
Reply.
There was a court order, Lordship, wherein wherein some candidates who got below the cutoff marks but were given appointed by the
post was that?
Page number 5, Lordship.
Reply.
Page number 5, affidavit in reply. Page number 5, para 10.
No, where is that copy of that order?
Lordship, I have annexed.
What was the copy of that order?
Page number
9 is that order.
Page 9 is the order, Lordship. Similarly, circumstances, Lordship.
They were successful candidates, successful impaneled candidates.
Lordship, kindly.
Page 10, last sentence. They were successful impaneled candidates.
Lordship, but their marks were below the cutoff mark, Lordship. I've mentioned their marks at page number 5, para 10.
What happened to them?
They were given appointment.
Given appointment.
Lordship.
No, you were impaneled. How could you be impaneled?
Lordship, I did not know my marks only. I was not impaneled, Lordship. Impaneled list, my name did not appear.
No, I don't understand. Unless you get above the cutoff marks, how can you be successfully impaneled? You are only impaneled, I suppose, if you have the cutoff marks, isn't it?
Lordship.
Or before that impanelment is done. What is the procedure?
Lordship, there were 3957 vacancies, Lordship.
No, impanelment, this impanelment concept is not clear to me. That happens prior to the examination.
No.
You have to be successful in the examination.
Successful candidate, after examination, successful candidate, thereafter impaneled, thereafter appointment.
Yes, unless you are successful, how can you be impaneled? They were successful candidates.
Suppose, Lordship, if I am
They're not even parties here. How can you direct it 2006 panel now? We are in 2025.
Another writ petition is pending, same footing, my lord.
By him?
Yes. Petitioner paid this writ petition for RTI information. Another writ petition filed in 2023, paying for appointment in OBC candidate.
What happened to that?
Lordship, is pending, Lordship. We have not moved, Lordship. We have not taken up for hearing.
This petition is pending and directed by the law.
We'll give you liberty to agitate that this prayer be in that. What is that writ petition? WPA?
WP 26334 of 2023.
WP 26334
WPA
26334 of
2023.
23. So you agitate this relief there. These are misjoinder of causes of action actually. The present writ petition was filed substantially with the grievance that despite certain informations having been sought by the petitioner from the respondent authorities, such information was not being furnished, pertaining to number of vacancies of OBC candidates and total number of appointment given to OBC candidates, as well as vacancies in respect of the selection process of 2006 for the post of assistant. This is primary.
Yes,
Assistant primary teachers. Full stop, next para. It transpires from the affidavit in opposition that after filing of the writ petition, such information has been supplied in its entirety by the respondents. Full stop, next para. Although learned counsel for the petitioner submits that in prayer small b within bracket, the petitioner has also sought for a mandamus commanding the respondents to consider the candidature of the petitioner if there is any vacancy of OBC candidates in the 2006 selection process, this court is informed by learned counsel for the respondents authorities that another writ petition, seeking the self-same relief, bearing WPA number 26334 of 2023, is also sub judice before this court. Full stop. Next para. Thus, insofar as the first relief is concerned, the writ petition has spent its force and has become infructuous. Full stop. Relief small b, being unconnected with the primary relief in the writ petition and having been sought in a different writ petition, cannot be granted within the limited scope of this writ petition on the principle of misjoinder of causes of action. Full stop. Hence, WPA 19475 of 2022 is disposed of as infructuous without any order as to costs. Full stop. Nothing in this order, however, shall preclude the petitioner from seeking relief small b sought in the present writ petition in the other pending writ petition bearing WPA number 26334 of 2023, if the petitioner is otherwise entitled to such relief in law. Full stop. No orders to cause urgent certified. একটা কষ্ট করে করেছে একটা প্রথম লাইনে করে the list of dates filed by learned counsel for the respondents be kept on record.
I'm grateful.